Wonderful. So welcome everyone to today's U&T training. My name is Michelle Rivero. I'm the director of the Office of Immigrant and Refugee Affairs for the City of Minneapolis, an office that is dedicated to ensuring that residents of our city who are born outside of the United States are able to achieve lives of safety, dignity, and opportunity in our city and in our country. It is an honor to welcome the National Immigrant Women's Advocacy Project, or NIWAP, to Minneapolis for today's U&T training, which will help us better understand how these visa classifications for victims of crime and trafficking represent a powerful tool to enhance community safety. Thank you so much, NIWAP, for being with us here today and for planning this training. City staff on both sides of the river also played an important role in planning for today's event, including staff from the St. Paul City Attorney's Office, including leadership of the St. Paul Immigrant and Refugee Program, the Minneapolis City Attorney's Office, as well as the Minneapolis and St. Paul Police Departments. Thank you very much to Edmundo Lijo, Tara Pettit, Judy Maidment on the St. Paul side, and to Kathy Waite, Brian Sand, and Jennifer Saunders here in Minneapolis for your planning work that have brought us to this day. I also want to extend special thanks to Giovanni Valise, the former U-Visa certifier for the Minneapolis Police Department, who has been a dedicated champion for the U-Visa program here in Minneapolis since passage of the U-Visa ordinance in 2017 until his retirement from the Minneapolis Police Department earlier this year. This event would not be happening today were it not for his encouragement, connections, and dedication. A couple of housekeeping items. As I mentioned earlier, restrooms and water fountains are out the door and to the left. A quick reminder that this session today will be recorded and a link will be made available afterwards. And I just want to say it is wonderful to see so many familiar faces who are working in immigrant and refugee inclusion, and to see new faces. Thank you for being here today, and I know we have a lot of ground to cover. So with that, I will turn the mic over to our distinguished panel from the National Immigrant Women's Advocacy Project to introduce themselves and get started. Thank you.
So my name is Leslie Orloff. I won't fully introduce myself right now, but wanted to thank the Office of Violence Against Women that is supporting these trainings nationally. So we're happy to be here. This is actually our first post-pandemic half-day training. So we're very happy to be back on the road in that respect. So let's start by introducing the faculty. So I'm Leslie Orloff. I direct the National Immigrant Women's Advocacy Project at American University Washington College of Law. I am by trade a family lawyer. Most people know me because of my immigration work, but there's actually many people in this room, I'm looking at one of them right now, that practice a lot more immigration law than I ever have. I helped write it. One of the reasons I'm very excited about being here is I was actually in the room drafting the U visa and the T visa and VAWA self-petition. And those are pieces of paper that sit on a book someplace without all the work that you guys are all doing. So we're very proud and happy to be able to be here to bring you this training today. Michael usually calls me the encyclopedia. You can ask anything, and I can answer, if there is one, about why, how, who they did things. But the real point is, doing what we can to keep victims safe, hold offenders accountable, keep law enforcement safe, and protect our communities. And that's what these laws are all about. So I'm going to pass it over to Jane.
Good morning, everyone. I'm Jane Anderson. I'm a senior attorney advisor with an organization called Equitas. Much like NIWAP, we're federally funded to provide you guys working on the ground with training and technical assistance. We're all former prosecutors who had specialized careers in sexual violence, domestic violence, stalking, and or human trafficking. We've been partners with NIWAP since before I started working with Equitas about 9 years ago. And it's always really great to be part of these trainings. I myself am a former prosecutor. And at one point, I was a certifier, being the chief of litigation for the domestic violence unit in Miami-Dade County. And then I ended my career having co-founded our human trafficking unit. So I hopefully will be able to kind of share our experiences with all of you doing the work here.
There we go. We're leapfrogging the microphone. Good morning, everyone. My name is Tara Patet. Is this working? Yes. Prosecutor with the St. Paul City Attorney's Office. I've been a prosecutor for 28 years, focusing mainly in the areas of domestic violence, elder abuse. I've done some community prosecution. After that amount of time, I've probably done a little bit of everything. I've also prosecuted cases through a joint project with the county attorney's office, so I've done both misdemeanor and felony prosecutions. I am also our certifier for our office. I have been for a number of years. And kind of have been able to watch sort of the evolution of this work and see really what a difference it makes when people like yourselves are coming to trainings like this, and the difference in the outcomes it makes for victims. So I'm excited to be here with you today. I also oversee our victim witness unit. So we're doing a lot of work on outreach for victims and getting people to understand that these VAWA remedies are out there.
Thanks, Tara. Good morning, everyone. Thanks for having us. Good to see some old friends and excited to meet some new friends here. I worked in Massachusetts as a police officer for 32 years. I retired just before the pandemic, so it didn't really last long. I'm back on the payroll helping out as like a special investigator, but still very much involved nationally on these projects. Been working with Leslie. How many years has it been now?
15, 20.
Yeah. I mean, it's great work, but it's work that has to continue. You know, if we let up on the gas pedal a little bit, and there's a lot of turnaround in our agencies, things start to slide. So it's work that has to continue to be done, and passing off the torches and that type of thing. But we're really excited to be here today to share this really valuable information with everybody. I apologize about my voice. Lost my voice a few days ago, so it's back this morning. So let's just hope it stays for just 3 hours, right? But thanks and welcome to our training.
Great. So what I want to do, each of you in your packets has an evaluation sheet. And as we kind of tell you a little bit more about the technical assistance NIWAP and Equitas offers, if you could fill out the pre-assessment part, it's like the first question or two on the sheet, that would be great to kind of assess your knowledge of the U visa as before we get started today. But while we're doing that, I want to tell you a little bit about NIWAP. We provide training and technical assistance nationally to around immigrant survivors of domestic violence, sexual assault, human trafficking, stalking, dating violence, and child abuse. And that we're available to do all kinds of technical assistance for you. One of the things we have that I'm going to have Mike tell you a little bit about, and that Mike and Jane run. I'll turn it over to you.
Yes, so we do these law enforcement and prosecutor only virtual roundtables. It's a really comfortable setting conversation. We have a certain topic we're going to talk about, but we really branch off and talk all things immigration, language access, some other things might come up with domestic violence response, that type of stuff. We don't have a date for our next one yet, I don't think. We're kind of doodle polling it, but please keep that link, sign up. Once you sign up, we'll have your information. We'll send out emails on a regular basis, letting you know when the dates are coming up. And it's a really good opportunity to not only kind of expand on your knowledge about the topics, but also ask questions and really start the process of the other things that NIWAP offers, which is like hands-on help with issues that you might have in your community. So definitely sign up for that if you are. And if you're under the umbrella of law enforcement, like in the prosecutor's office, but doing other work and aren't necessarily a prosecutor, you still would qualify to be on it.
Right. And so NIWAP, we can help you on individual cases, we can help you develop policies, and our work is not limited to immigration or the U visa or the T visa. Like for those of you that might be victim advocates or the victim advocates in your agencies, we're experts on the intersection of immigration and access to public benefits that are needed to support the victims, and also all the family law issues that come up with immigrant survivors. Just so you know, nationally, we also, those of you that are working with judges who you think might be interested in learning more about this issue, we have a community of practice, just like we have the roundtables for law enforcement and prosecutors. We have one for state court judges around the country. So there's information in your packets about that. Sorry, not the clicker.
Okay, so this is really just an infographic about Equitas. I want to share it with you. Those of you that are prosecutors in the room, which, by the way, this is like a record-setting number of prosecutors to show up to one of these trainings. Really want to give you guys a big round of applause. They're always the hardest to get here. But this is our information. We strive to make sure that the information we provide to you is innovative. It's the latest social science, the latest case law, but also practical so that you can take these strategies and implement them as soon as you go back into your offices. And we do that through resources and consultations, webinars, trainings around the country. We also have some office hours. Any of you that are maybe interested in how the Counterman U.S. Supreme Court decision may affect your stalking cases, that's U.S. Supreme Court case came out last week. We're doing our latest office hours on that. So take down our information and just let, we're there for you to be a resource.
Okay, and then we have, as I said, we handed out the flash drives, and the USB drives have materials on them, including a U-Visa toolkit, all the DHS resources, policies, memos, tools. It's loaded with information. There's also a web page that will email you after the conference, where you can download all of that information from a web page as well related to this training. Back to you.
Okay, so we're going to get started into the meat of the presentation. And one of the things I wanted to say right away was that we do tend to use examples where women are the victims and men are the offenders. And that is just reflective of the research that's out there and some of our lived experience having handled those cases. But I just wanted to make sure I remind myself and you that women, men, children, people of all genders and identities can be victims and do qualify for both U visas and T visas. We also tend to talk about it in the context of domestic violence, intimate partner violence, and sexual violence. However, there is a slew of other violent crimes that can have someone qualify for the U visa, and of course trafficking for the T visa. So that's my caveat before we kind of turn it to you and get a sense of who's in the room, and Mike's going to do that.
Since in true fashion I don't listen to everything you say and I challenge a lot, is it really a lot of prosecutors in the room? That's what I want to know. So how many prosecutors are in the room? Okay, it's not like 90% like you told me. Thank you. Law enforcement? Some are obvious, right? Law enforcement? Jane, I'm right there with you. We have probation, parole, advocacy. Now, for those that raise their hands, advocacy, are you in the prosecutor's office? So there's a little bit of both, some of each. Who are we missing?
Law enforcement?
I said law enforcement.
No, not the victim advocates in law enforcement.
No, I said law enforcement, right? Police officers? Oh, that's what I was just saying. So if you're victim advocates and you're if you're working under the prosecutor or the law enforcement umbrella, anybody? A couple. Yeah. Same two hands, right? Who did we miss? Because a few people just, is it because it's early? Yes, ma'am.
There's some of us here from Edward County, and we're in like human services and then the Office of Multicultural Services.
Oh, nice.
Serving non-citizen applicants with a variety of concerns.
Great. Well, excellent. Your input will be very helpful today, so thank you for being here.
And other civil legal service agencies that work.
So other civil legal agencies, service agencies? Excellent. So we have a good mix. So we should have a great day. And like you said, I was so excited this morning to see this lineup. I mean, this is a great attended event. Monday morning, everybody's anxious to be here and with us, so we're excited. So we have what's our next? Our goals and our objectives, I think? Yes, so here are our learning objectives. Pretty straightforward as to kind of what we're talking about. We want to make sure that after this training, you're going to be able to better do the things above. Support U and T visa applications, so have the knowledge, have the foundation to understand what they are, what they aren't, who signs, what the process is, that type of stuff. And we'll go through all those slides and information then. In doing that, we're improving victim safety and the justice system participations of, holding offenders accountable, keeping victims on board. Basically, in a couple of words, it's community safety. It's officer safety. It's safety of everyone involved, right? And we'll talk a little bit about that. And then developing pretrial and trial strategies to overcome common defenses. And the first thing I think about is Jane, when that bullet points up there, and it's like, what do we do when we're afraid to mention that there's a U visa in process because we have a court case, we want to wait, we don't want the defense to find out about it. And the great news is Jane has a present for you, all wrapped up with a nice bow that she will open up a little later on, and we'll all be happy when that comes up in court from now on. So that's our day. Those are our learning objectives, and I'll pass it off to Leslie.
The day, so you have to stay the entire day.
We keep doing it. Okay, so so
You want me to do that? Oh, I thought your slides came up after that. My bad. We prepped late.
that one?
Effectively communicate with victims of crime. Basically, what we're talking about is language access. So we're talking language access when we talk about that. And I don't have the clicker. I don't have the control.
No,
It's
I
not.
have, it's going
Yeah, you're next. Yeah.
Okay.
I'm sorry. I didn't
So-
do that title slide. Yeah.
There we go. So where are you? Too many things in my hands here. Where are you seeing immigrants come from? Like, where are you seeing immigrants from in your communities that
And
you're
you can
serving?
use your microphones.
Use your microphones, or
now.
I'll try to repeat. You can just shout them out. But where from in
Where?
the
What
world?
countries?
What countries?
Ecuador, Venezuela, Colombia, Somalia,
Mexico, Somalia. African countries.
Mexico, you said?
Which African countries? Liberia. Okay.
I heard
Where
Ukraine
else?
over here, Leslie.
Okay. Yeah. Any working around universities or military bases? What else are you seeing? No? No place? Any other Europeans? Any other Canadians? Australians? You gotta have Canadians.
Yeah, Eastern Europe, Western Europe, Asia.
A few Russians. Okay. So, Minnesota's, where can I see this over here? Mike, can you move? 'Cause- okay, so in Minnesota, about 8.7% of the state's population are foreign born. Basically, over 20% of the children in Minnesota have one or more immigrant parents. So, how many of us in the room here are either foreign born or have one or more immigrant parents? Hold your hands up for a second. Do we all look like you'd expect? No. That's the point, is that you'll have immigrants that look like me. You'll have immigrants that look like everybody in this room. And so you can't make assumptions about who's coming from an immigrant family and who might be afraid or concerned or need a U visa or something like that. And when we wrote the U visa, we understood that. That's why they're available for people who are lawfully in the United States on all kinds of visas and people who are here undocumented. In Minnesota, you pretty much nailed it. I didn't hear a lot of Asian countries, but if you look at, actually, Asia are the biggest immigrant populations in the state, followed by Africa and Latinos. And that you have a significant part of the population, 41% of the foreign-born population in Minnesota is limited English proficient. The next two slides, these are a lot of data, but you can have them and use them for your, the working you're doing in your communities. Two things. A lot of people are speaking languages other than English at home, and some of those people may or may not be limited English proficient. So you could have a lot of people speaking Spanish, let's say, at home. But limited English proficiency is highest, as you can see, among the Khmer, Vietnamese, Thai populations in Minnesota. And these are the languages that are spoken most often at home. And you can see African language, Amharic, for example, quite high on the list.
So I guess the next question would be, what does that mean for us in the work that all of us do in the room, right? It means that we need to pay attention to the fact that we have a lot of individuals in our communities that don't speak English as a first language, right? So luckily for us, the DOJ has given us Title VI. There's been some laws since that was put in place, some guidance, model guidance that we'll talk about, that gives us direction as to how we're going to do that if we're in an agency who, it's everybody, but I think we should mention that if you're receiving government funding, then it's required. It's not a suggestion that, hey, you really should do this. If you're receiving any type of government funding through any funneling system there is out there that comes through the state, we're required by DOJ law to actually provide meaningful access to those who are LEP in our community. So that's a really important thing to have. Do you want to add to the clicker? Yeah, why not? You don't give the clicker up often. This is, I feel privileged. So we want to provide that free of charge, like it says up here. Anybody who needs it, anybody who requests it, if we as individuals, and of course we're focusing a little bit with me up in front of the room on law enforcement, if we need language access to be able to, get information from individuals, whether witnesses of crime, victims of crimes, others, we're going to utilize that. We need to let them know that that's available, so there should be some type of quote-unquote, if you will, campaign or advertisement or postings that are up there letting individuals who are LEP know that in our community, you have access to that free of charge. You can come to the police station. You can interact with the individuals represented here and others to obtain that meaningful access. And it's going to be provided in their primary language. Now, that sounds like a whole lot, right? But really, in the working model of this, when you're working it in your community, it really isn't tremendous heavy lifting. We weren't doing it for a long time in our community, and we're doing it really well now. The job's never done, though. I mean, we're in a community where I worked where we have hundreds of thousands of tourists that come in every single year. Can we cover every single language with, face-to-face qualified interpreters at our disposal when we need them? No. But we have other tools that we utilize, like language access lines, that type of stuff. You also have to have, and I think it's coming up, you have to have, important information translated in the languages that are out there in your community. So it's a constant thing where like we didn't hear Asia a lot, like Leslie said, those types of individuals live in the community, but we saw the stats. So now you know that. So if you don't have language access and translated documents in that language, the languages represented in those stats, make sure you start working on that. And we have that policy is in the packet?
Yeah.
Yes. Keep clicking. I talk too much.
No.
And this is just basically describing what meaningful access is. I mean, it's pretty straightforward. It can't be delayed. It has to be, similar and the same as if we were talking to somebody who spoke English as a first language. So if I spoke Hmong and I was in your community, I should be able to access all the benefits of someone who spoke English in your community, right? And it should be fluid. It should be happening. Obviously there's steps that have to be taken. It's not the same as walking up and talking and you come up to me and you speak Hmong. I don't. So, but I have things right there at my disposal that I can utilize. Exigent circumstances. Now, to me, this speaks straight to law enforcement. So, what is exigent circumstances? One of the officers that are in the room. What does that mean? Big words. Exigent circumstances.
You don't have time to get a warrant.
You don't have time. It's a crisis moment, it's an emergency. You need to get information. So when I think of this, we mentioned that we use domestic violence a lot in our examples. Let's think about a 911 call to a house for a domestic. 911 signs recorded. Help, help. My boyfriend's beating me up. My boyfriend's beating my mom up. Help, help. Somebody get here. We go charging down there. We get in the house, and there's kids crying, and there's someone with an injury. There's all kinds of dishevel going on in his household. We have to get information to find out what's going on, right? Top things. Safety. I want to be safe. Anybody injured? Do I need to get medical attention here? Where's bad person? Where'd they go? What were they wearing? Did they have a gun? Did they have a knife? All those things that are exigent all make sense to the law enforcement officers in the room. We're not required. DOG recognizes that. We're not required to use a qualified interpreter to do that. We're required to use the best person possible. But in that exigent circumstance, it might not be a really good person. It could be a family member of the offender, right? So just so everybody knows, it's a lot to ask when it's on paper, but in that working, in the community thing, when you're out there doing your job, that's what we do anyway, right? We're going to ask anybody. I mean, and I'll say it, it's not the most popular thing, but you might have to use a child. The child, 12-year-old kid on the scene, might be the best person right there just to give you that basic crisis, injuries, where's mom, where'd bad person go, all that kind of stuff, right? But then, when it gets to the point where we're investigating, now we've secured the scene, all that exig is gone now, put the bolo out, look for the person driving this car, riding this bicycle, has a gun, whatever it is. Now, what happened tonight? And we're going to ask questions. We're going to develop probable cause. That's the access point that it gets to DOJ, requirements, Title VI, qualified interpreter. We need to do that. So if you don't have somebody that speaks Vietnamese, that's a qualified interpreter that you can bring in on a list or that works for your agency, you may need to use the language line to get that, make that happen, right? And I'm sure you've heard of that. Anybody heard of the language line before? Hopefully everybody has access to that. So yes, I think I covered that.
And
So
I
here-
think we just, want to put this in before we even start talking about U visas, because if we're not communicating with the victims that we're serving, not only are we maybe going to mess up our case. I don't know. I worked in Miami, so interpreters and interpretation problems occurred, if you might imagine that. But also the idea that, we need to be doing this successfully if we're going to get to the next step as well.
And we want to put bad individuals to jail, right? We want to keep our community safe. This all leads to that. The vital materials, like it says up here. So this is stuff that we want to be doing, right? We want to make sure we get the right information. We could spend a couple of hours talking about this. There's been some horrific cases out there. We've had some bad cases in my jurisdiction. Infants murdered by their father, and the person gets off on a manslaughter, is out there walking the streets already because we did our job the wrong way, and we used a bilingual officer to do the interpretation for that interview who didn't know how to interpret and was paraphrasing all that. Now we have a murderer of an infant that's out walking the streets. That's the type of stuff that happens when we don't follow this and use qualified interpreters or a qualified interpreter resource to get information from witnesses, suspects, all the above, right?
And Mike, before you move on, can I just add too? I'm seeing more and more cases where there are children that are used as interpreters at the scene, and of course, exigent circumstances are often such that you have to do that. Just for law enforcement to keep in mind that often, especially in DV and SA, victims won't give the whole story, particularly with sexual assault, if the interpretation is being done through their child. And so, for investigators, it's an opportunity to really be broad and kind of examine other crimes that may have happened, start sort of fresh with getting a statement.
Definitely, for sure. So this gives you an idea of the language around what a qualified interpreter is. When you have a language access plan in place, you're going to have, things in place that are going to direct you to do it the right way. So hopefully those policies are in place in your agencies. If not, they're being processed right now. I did it for a long time. I was in the detective division for almost 20 years. I ran the special crimes unit. I had my group of 2 or 3 officers that spoke a couple different languages that I would use consistently in, high, serious cases, just serious felony cases. And wow, was I doing it wrong when I had the officer interpreting for me. And it's almost like you knew it was going on, but you didn't pay attention to it. When I ask a question, victim gives a 2-minute answer, and he says, oh yeah, they stopped off at this roast beef place on the way to the house, and that's where the incident happened. No, there's a lot more information there, right? So it's word for word, that type of stuff, so.
And let me just say that first of all, we have a model policy, a sample model policy around language access and U visas on the flash drive that we're handing out that you can take a look at. And the simplest way to think about this is the moment you start collecting information that's going to go on a police report that, Jane or Tara or some prosecutor down the road is going to need as part of their criminal case, you need a qualified interpreter. So that's the big difference between, it's exigent one thing, but when you get to the point where you're starting to put things in a police report, that's when you have to have the qualified interpreter.
And we're going to move on, but last thing I'll say is, please, any questions about this, you need any help getting this type of stuff in place, call us, utilize the numbers that we'll give you at the end of the presentation so you can reach out for some support. And I can tell you from personal experience, it's not a whole lot of heavy lifting work, like I said. We have over 24 qualified interpreters on a list that we can call 24/7 in a bunch of different languages because NIWAP helped us out with some funding through some grants, and we brought someone in and we invited all the communities around our town and got a bunch of individuals who are bilingual qualified as interpreters. It's not the same as, is this the courthouse? This building across, like over there, if you want to be an interpreter, it's like taking a college course, right? I mean, I have bilingual officers like, I'm never going to be on that level. But being a qualified interpreter, it's really just understanding the do's and don'ts of what it means to interpret. That's the main part of it.
So now we're going to move on to kind of the core. Oh, question in the back. Yes.
Could I ask for the law enforcement folks in the room to just indicate whether they have access to the language line or a language line I missed?
So the question is, can the
All law enforcement, raise your hand again real quick.
We do.
You have it, access to language access, everybody? Does anybody not? Excellent.
Okay. No, good question. Okay. Mike, can I have the clicker? Okay. So now we're going to move on and talk a little bit. We're going to start talking more in depth about the U visa. So before we start, we're going to be talking today about the U visa and the T visa mainly. But I want you to, what's really important to understand is when Congress wrote these laws, there's actually a broader range of laws that I just want to be sure you're quickly aware of. Because there are some laws, so which immigration status somebody may qualify for. Many crime victims will qualify for multiple forms of immigration relief. And which one's the best for them to pursue will depend on a number of things. Some take many, many more years than others. Some go faster. Some are available only to children, but go faster than the cases that are available to their parents. And which public benefits in Minnesota and in any state they qualify for depends on the state and the immigration status, with some forms of immigration status, like trafficking victim visas, having much more access to public benefits than U visas.
Right.
So it's really important to kind of understand that and understand, so how many of you have worked with a crime victim where, a domestic violence case, where the abuser was a US citizen and the spouse or child victim were non-citizens? Okay. And they were married. Those are all VAWA self-petitioning cases. 3 months after filing VAWA self-petition, they get access to benefits. And some get work authorization if the husband is a US citizen. So it's just important to recognize all of those. We have screening tools in your materials, and the major, and then how many of you have worked with a domestic violence victim where, whether they're married or not, they're the parent of, the victim is being abused and her child is being abused, and the abuser is the child's parent, other parent. So a child abuse case. All of those cases, any child who's a foreign-born child who's abused by a parent anywhere in the world, abroad, abused, abandoned, or neglected by a parent anywhere in the world, including in Minnesota, is eligible for special immigrant juvenile status and will get work authorization and a driver's license 6 months after they filed, compared to 5 years on the U visa program. So it's just important to screen for all of those cases and understand that Congress created this many roads in to essentially lawful status for immigrant crime victims.
So why do you think that Congress did this? Why do you think these forms of immigration relief exist?
Because they exist.
Because it's happening.
They exist.
Military
yeah.
people,
They exist.
they exist. Yeah?
Otherwise you won't get any cooperation, no one will report.
Yeah, so no one will report if they're afraid, and you won't get cooperation, which means you won't get investigations, which means you won't get prosecutions.
People are afraid that interactions with law enforcement will lead to deportation.
Yeah, this fear that law enforcement and deportation are so closely tied that if you talk to law enforcement, you will be subject to deportation, right? And who tells them that? The abuser, right? Okay, so good.
And there's another thing because.
Do you mind just using that a little bit?
Sure.
Thank you.
This is for everybody too, just want to say this. Sometimes these mics can be really intimidating, but these are really easy to use. If you just push the people button, the person button, when it's green, you're audible, speak into the mic, draw the mic towards you like this. And then when you don't push the button anymore, just press it again. When it's not green any longer, you're no longer audible. Thank you. That ensures that everybody can hear the question.
Thanks, Michelle.
So I was going to say that a lot of times the victims are dependent on the abuser for support. So they are really stuck in a lot of ways and they have fear. But if they do know and realize in their circumstances, they could potentially be eligible for assistance if they cooperate. The probability of cooperation would be higher.
Yeah. And thanks, Louise, for mentioning it's not always about deportation. It can be about financial assistance because maybe only that person has lawful work or has work. So there's all these sort of collateral fears and consequences beyond just deportation. So, yes.
You mentioned children being like abused or neglected. Sorry, neglected. Can you define more in the law what would define as being a parent being neglected towards
So
their children?
that's actually a great question, and there's a really easy answer. Even though these cases and the abuse or neglect or abandonment could have happened anywhere in the world, it's Minnesota law that controls. So however Minnesota law defines child neglect, either in the criminal context or for child welfare purposes, is how it's defined for immigration law purposes.
And the reason I ask is just culturally, some have a culture where it's totally fine to leave their children out and about, responsible. They trust their child, but that's why I was just wondering, culturally, what's the definition for that?
It's a good question. And I think it would turn on, how state law in Minnesota handles those things and what exactly it is that they're doing.
It's not uncommon for, in my experience in the work that I've done, it's not uncommon to have those cultural norms conflict with what the laws are of our jurisdictions, and then it ends up being a neglect situation. So, again, education is huge. Collaboration with all your partners that kind of can get that message out there to minimize those instances from happening. Hopefully that helps. I mean, someone here would have the actual law, somebody in the prosecutor's office or a law enforcement officer, if that's really what you're looking for.
And we have it on our website, so I can give you a link to get it. So we have a special immigrant juvenile status bench book where you can look up the definition of child abuse, child abandonment, child neglect in every state. It's on our website, so I can give you the link.
About the domestic one, get into it. So another thing that I've seen is where there's a domestic that's happened. However, the parent refuses to acknowledge, like doesn't try to cover for, even though we know that it's going on. How do you suggest to kind of not push, but kind of encourage of what the U.S. can offer them? Because I don't think they know, and they're relying on that supporter because they don't know that we would support him.
He's just asked like the question we're going to talk about all day. What's your name? Jason, thank you for just setting us up like that. Yeah, I think that's one of the big things that the U visa is here for, right, is to help bridge that gap between our immigrant neighbors and how the U.S. system works, right? So some of the legislative intent behind these forms of immigration relief are on a micro level, like on a case-by-case level, right? This person, this victim of a crime, now has access to immigration relief, which allows them to stay here and participate in an investigation and prosecution with us and without the fear of being deported, right? But there's also these macro level intent behind it, which is to increase on community levels trust between law enforcement and immigrant communities. And I think this comes into play when we start looking at case-by-case analysis, for us to always remember that it's not this case, this file in front of me. That's not the only purpose behind it. It's a bigger picture of how do we improve community relations? How do we improve the fact that people are going to feel free to come and call police and ask for help? And then through that, hopefully, your victim service folks that are working with police officers and working with prosecutor's office are also able to connect them with community services and community organizations that are able to provide them financial support, access to benefits, all of this extra kind of resources that they may need so that they can leave an abusive person without those resources. So it's all of these reasons behind the legislative intent. And when we start getting into the nitty-gritty, I'm going to ask you again to remember not only this case, but the broader idea of community relations.
And if I could just jump in, one more piece of that is that when we look at the social science research we've done around this, this is why these community collaborations are so important, and having victim advocates at the table, whether they're systems-based or non-systems-based, because what we know is, for example, I did protection order litigation for years, trying to encourage victims in exactly that situation to come forward and get help through the protection order system. And what we know about protection orders and immigrants is they do not access the courts for protection orders without a victim advocate or an attorney. So that's where you start. And then those victim advocates and attorneys that the victims begin to trust need to then be connected with the systems-based folks in this room.
So this is the U-Visa statistics as of 2011, so we could surely update them. But what you'll see, and kind of what plays into that caveat we started with, is that almost 50% of those that are applying for U-Visas are doing so because of an incident of domestic violence. Second on the list is sexual violence. Together, those two make up almost 75% of the U-Visa applications. And so that's why we often talk about it. But it's important to know, and we'll give you all of the qualifying criminal activity, that U-Visas are available to almost any victim of mostly violent crime, but some other workplace crime as well. Jason.
Sorry.
No, we love it.
Does a U visa take into effect the severity of the domestic violence?
No.
Or is it just if it's domestic, they treat all domestic cases the same?
Again, it's going to relate back to your state code. So if it qualifies as domestic violence, I mean, often there's not a crime that says domestic violence, so it's going to be assault, battery, stalking. Then it'll qualify under the U visa as well.
Domestic violence qualifies.
Yeah, so misdemeanor and felony. Now we're going to get into the nitty details, but there is going to be a showing of harm that the applicant needs to show. So, but it can be a mental harm. So we'll look into that as well. And Louise?
So for circumstance in Minnesota, does the crime or the violence have to occur in Minnesota, or could it have happened somewhere else and they're coming here for safety?
You do not need to apply. Like if you were applying for Minnesota, you probably would want to refer on the paperwork to the criminal code that would have applied where it happened, but there's no reason why they couldn't apply from here. Yeah. And there's,
the
I mean,
certifier-
the law doesn't really change all that much on most of these from
But the
state to state.
certifier has to have some knowledge of it, so you're likely going to be applying where the crime occurred, most likely.
Boston to get the reports, you can still do it.
Okay. Yeah, that's what I was kind of thinking. I just wanted to make sure.
Yeah.
Thank you.
But there's also interstate things, so somebody could be harmed in one place and fled here, and this is where they reveal, and so you could, it's immigration law that's applying, so you could apply the laws of any of the states, and anything that's sufficient for a protection order, not just a criminal case, in the state where it occurred is sufficient. And there's one more in the back.
Usto?
I just does the victim have to press charges against the abuser and in terms of being eligible for that U visa?
So you're just going to jump ahead. So instead of answering all these questions right now, I'm going to just have you bookmark that, and we will definitely be getting to all the nitty gritty. Yes. Yes. She was just asking if human trafficking included sex trafficking and forced labor, and it would.
Sorry. I have one more question. I don't know if this will be in the slides, but as Louise was saying, there's a kind of dependency on financial from the abuser. So if these victims would qualify, the next step would be, how do they get the resources? Because they probably don't know anything about immigration law. So do you guys have any suggestions on how they would get resources to apply, to get an immigration lawyer that could help them with this process? I don't know if there's like anything free for them to do, like kind of.
So that's really where you've got to look at your community resources, but more often than not, there are going to be some free resources or resources available on a sliding scale. We've got Kathy right here raising her hand.
So I work at one of those agencies, the Immigrant Law Center of Minnesota, but on, I don't know if you have access to Loon, which is one of the, or Law Help MN has a lot of the civil legal agencies that, and all different types of areas of law that they help. But if you look at immigration, it'll pull up like the local legal aid offices and other nonprofits and what they specialize in.
Okay.
And let me just say, Kathy, you're going to check me on this, but I think it's probably as true in Minnesota as anywhere else. The last thing you want to do with an immigrant survivor is send them to an immigration lawyer who's going to charge them a boatload of money, because those immigration lawyers in this area of the law don't know what they're doing. So you really want to go to your legal services, your Catholic charities, go to your local shelter and ask them who's volunteering for them. There's lots of ways to do it, and then we provide support nationally to all those lawyers.
And just to follow up, there's others in the room too that have other agencies like Standpoint and International Institute, and so some of my colleagues at this table. So we're out there, please.
During the break, everyone go to this table and get their cards, okay? Enrique?
So I'm a community advocate with the St. Paul Police Department, and U visas, T visas were not really part of my job description, but because I work within the Latino community, a lot of people were reaching out to me. I'm not an officer, so I think they were a little bit more comfortable, but I seen that there was a lot of like kind of bad scams type of stuff happening, where they were reaching out to apply for a U visa and being charged to have a copy, and I would print out a free copy for them. Or then somebody would have to, a lawyer would have to review it and charge them. Or sometimes when they submit it to the police department, they would be charged to do that. And I didn't want to say, hey, I can do all that for free for you, because that wasn't necessarily my job, and I didn't want to be overwhelmed with it. But are you seeing a lot of that? And I had to do my best to train myself, take some training, and then also try to reach out to different people in different communities that did some of this type of work to pass that info on to some of the families. So what other things can we do to make sure we get this info out to the people that need this without them getting scammed or getting charged a ton of money?
Well, immigrant communities are often targeted because they're vulnerable. So the same reason that an abuser might target somebody that doesn't have status, so will other sort of nefarious actors. And so we have seen, and even worse than that, people saying, guaranteeing a U visa for $10,000. And so there are, within USCIS, there are a lot of fraud detective kind of processes in place. And so there's some going on that end. In larger cities like Los Angeles, they're doing a crackdown, and they're trying to proactively sort of find these nefarious actors and try to crack down on them. But essentially, it's just trying to get out the good word over the bad word at this point.
Too. So the Office of Immigrant and Refugee Affairs in the City of Minneapolis and the St. Paul Immigrant and Refugee Program, one of our objectives is to ensure that people are connected with immigration legal service providers. There are a number of free legal services, as people have said already. We also have a list of free legal service providers who are happy to share that information, and just want to make sure to distinguish between people who are scamming and taking advantage of individuals. And there are also private immigration attorneys who assist people in applying for U visas. So that is something to be aware of as well, that there is a distinction between people who are scamming or charging a whole lot of money for something that should and must be free, and private immigration attorneys who have competency in U visas. And we're very fortunate to have a number of legal service providers, a number of excellent immigration attorneys in the Twin Cities area. Thank you.
You are allowed to charge for your fees if you're an immigration attorney. Sorry if I wasn't clear.
Yeah. Okay, one more question.
I just wanted to add a quick comment that I think the problem with some of the local private immigration attorneys is that they'll often charge like a retainer fee of like $500 or $1,000 to basically move forward and request a certification. And with the Hennepin County Attorney's Office, I think we sometimes get frustrated when we get these like 70-page U visa certification requests when we simply are looking for a release of information and just like a briefly stated email request about a case. And so I think our preference, of course, is to try to see those pro bono attorneys get connected with our victims for the obvious financial reasons.
And discovery reasons.
Yeah, right, which we'll talk about later.
We'll talk about that later.
Okay, all right, I can already tell we need a whole day with this group. This is a fabulous group, you really, really great. But so we're going to spend the rest of the morning talking about the U visa process and the certification in particular, and kind of how you're weighing those as certifiers and as people who are involved in this work. But just sort of before we kick off into that, something for you to be aware of is that our victims in Minnesota, our Victims' Rights Act actually includes a mandate that each office, that each certifying agency have a designated certifier, and that those designated certifiers process any certification requests in as fast as reasonably possible. In any event, it shouldn't be anything less than 90 days. I think 90 is really long, actually. And as we get to the next slide, we'll see that your own local ordinance requires a shorter period of time. But in any event, 90 days under state law, 14 days if the person's in removal proceedings. There has to be a designated certifier. So if you receive one of these as a prosecutor or law enforcement and you are inclined to sign them, you can't. You need to forward that on to your agency's designated certifier. And that certifier is also responsible for making sure that there's a language access policy in your office and that these materials are available to victims. Materials about the certification process are available to victims in the various languages that might exist in your community. The Victims' Rights Act also prohibits disclosure of immigration status and also notes that regardless of the outcome of a case, whether a case is still in an active investigation or prosecution, certification can be signed. As I mentioned, there's a Minneapolis ordinance that actually prohibits city employees from inquiring about immigration status. So this is kind of a big deal, and St. Paul has a very similar ordinance with real similar language. Now, for prosecutors, for city attorneys, we of course can, if we need to, as part of a case, we can inquire when it's relevant to our case, and that can be a tricky thing, I think, for prosecutors' offices. You want to be able to give victims information about certification. You don't want to scare them off by immediately inquiring into their immigration status. So you have to be really careful about how you nuance those conversations. In situations, if we're working with a pro se defendant and we need to inquire as to their immigration status, that's certainly allowed under the ordinance. Oh, yep. Oh,
I can't talk into the clicker.
Try it.
I just wanted to speak to the law enforcement officers in the room. There's lots of ways that we can not allow that to get in the way of us providing this service, this ability to reach out to this. So in your questioning, like when you're asking about, what threats were made to you, why were you afraid, to call the police? Like you formulate your questions in a way that's going to get the information you're looking for anyway. And at the same time, that is an opportunity as you're building that trust with that individual you're speaking to, whether it's a victim or a witness, the opportunity for them to let you know what's going on. So, and I would defer to Tara to correct me if I'm wrong, but as long as they're providing the information to us and now we find out through that avenue, then it changes the game as far as what we can say. So just the questions you ask can make a huge difference in how you actually ask those questions.
Yep. And as I mentioned, it also within your Minneapolis ordinance, and this is true in St. Paul as well, certifications have to be processed within, first of all, they have to be processed. It can't be a thing that comes into your office and you think, well, gosh, I don't know what to do with this, and therefore I'm just not going to do anything at all, or let it sit on my desk. We do have to process these when they come our way. We have to do that within 30 days under our local ordinances, both St. Paul and Minneapolis. Like the state law requires, like the Victims' Rights Act requires, you have to have a designated certifier in your office. You have to have a language access policy that is available for victims, and information about the U visa process itself available in multiple languages. It notes in the Minneapolis ordinance that it gives sort of a definition of investigation or prosecution, and we're going to talk about this throughout the morning as well, how broad that definition means. It means the detection, investigation, prosecution, conviction, or sentencing. Any of those points, if a victim is helpful or will be helpful or has been helpful in any one of those things, you can sign a certification of helpfulness. And the other thing that's nice, I think, about the Minneapolis ordinance is it actually states that there's a rebuttable presumption that the victim has been helpful in this regard.
Okay, thanks. Yeah, so with all of that information in consideration, how does this help us? And it says up here in our domestic violence investigations, but this is for all of our investigations out there in our community, right? And it's not just that, it's also having a language access plan and having a welcoming atmosphere to the immigration relief that's available in our community. So when we're doing all those things together, how does that speak towards community safety, officer safety? As a law enforcement officer, I was so impacted from an experience that we had in the training room. We were doing a training on the East Coast, just outside a very large metropolitan community, and not like the group here, because everybody was banging down the doors to get in here early today, but in a lot of the trainings you go to and you present at, you have your hostages, your vacationers, your voluntold people, and the people that want to be there, right? So we're in front of the room, and doing our thing, and there's this guy in the back that was like 4 feet wide, full of muscles, ate nails for breakfast, the kind of guy that we want to be our partner on those overnight shifts. We're working on those areas that we want to have a little backup. And we notice, you take your break, you're like, oh, that guy in the back of the room with his arms crossed, like, he's not happy to be here. Like, I'm not even looking at him anymore. I'm afraid he's going to get up and really throw a missile at me. And then towards the end of the day, guess who stands up? And we're all like, oh, God, what's he going to say? I'm looking at Leslie like, what's going on here? And this gentleman stood up. He was a detective working in a special crimes unit working with gangs. He and his partner had infiltrated one of the most violent gangs in the country, infiltrated high up. So just imagine that. So he's in there protecting his community in a very high-risk situation. Unbeknownst to him, there's an investigation going on with the girlfriend of the gang leader who was physically, sexually abusing her, letting other gang members do the same. She was undocumented. All those things that we talk about were happening in her life, but the Domestic Violence Special Crimes Unit was working with her on the side and, talking about the U visas. There was a signing going on, all the stuff that we do when we work in those units. I was in the Special Crimes Unit. They were doing their job. Because of the trust and the relationship and all these opportunities that now came to light, like who was mentioned? I think you might have mentioned, somebody mentioned about, well, how do we let them know, like how we can help them and how this thing's out there for them? All that stuff happened, and she told those investigators, and just so you know, my boyfriend and all his guys, they know there's 2 cops that are in the gang, and they're going to kill them. And if not for the fact that this stuff we talk about today was going on, and those relationships were happening with that survivor who was undocumented, that officer wouldn't be there that day to tell us a story, nor would his partner. And I could stand up here and give you a bunch of different similar stories, maybe not as straightforward and impactful and like that dangerous situation he had. And another piece of it, and I know we don't have a ton of time to talk about this, but when you're doing it, it also uncovers in our communities, in your communities, everybody represented here, there's victims in the shadows. There's violent offenders in the shadows that aren't out there for us to help and or hold accountable, right? And when we're doing this stuff, and in my community, we had a sexual assault case. It was a case that spanned numerous victims, and it all came about because the owner of the restaurant was being investigated for basically, strong arming some of the employees, not treating them well, that kind of stuff. And because we were welcoming, as I say, and started working with that victim, we found out about victim number 2, and then we got video surveillance and found out about 3, 4, and 5, and really uncovered a really bad situation for a lot of individuals. So that's my soapbox 2 cents that I can give you for the time that we have here today, and I'll turn it over to Leslie.
So how many of you have worked on a case? Can you give me some examples from some of the work that you've done around the types of coercive control that abusers will use against immigrant victims? What kinds of things are you seeing? Anybody? Yeah. Exactly, threaten to call. Exactly. Yeah. So a common one, a U.S. citizen married to an undocumented victim, and then they're threatening to have her deported, and then she's afraid and doesn't know what her rights are at all, more or less. Yep. Yeah.
In my former life was mainly, and I have a couple cases, but that was one about this man who had basically told his wife, which he had 2 children, stepchildren that were not him, that she will be reporting him, then she will be deported, and then he will keep the kids out here.
Yeah. Deportation and separation from children as part of this coercive pattern of control. Absolutely. Do I have another?
I was going to say the same thing about the children.
Children, yeah. Mundo?
I actually had a case where U.S. citizen father, 3 stepsons, and the wife came in on a tourist visa.
Mm-hmm.
He refused to do the immigration process or withheld the petitioning for the spouse and the children, and was using that to control mom, and then was sexually abusing the 3 sons.
Yep.
And that went on for about 5 or 6 years.
You guys have nailed it pretty much. I mean, these are the kinds of things absolutely that we're seeing. I was going to show a video, but I think you've covered everything we have here. So basically, this kind of power and control dynamic that you're all describing exists in about over 70% of the cases where a U.S. citizen or a visa holder or a lawful permanent resident could file papers and there's domestic violence or child abuse going on. They use it to control the victim. And it's that power and control dynamic that VAWA, T, U visas, all of these visas were created to try to break that power and control. And that, and it's pretty much all these different forms of immigration relief, the way they use immigration-related abuse is exactly the kinds of things that you mentioned. And that we see this happening. So once victims file a VAWA self-petition or a T visa or a U visa, this immigration-related abuse doesn't stop. They keep trying to turn the victims in, which is why it's so important. So what happens is you've got a perpetrator actively trying to get the Department of Homeland Security to ruin your criminal case or your prosecution because they're trying to undermine that victim's ability to go forward. And the only way legally under immigration law to stop it is to get a VAWA self-petition, a U visa, or a T visa filed. As soon as it's filed, there's a system at DHS that puts a red flag on that victim that basically says, hands off. You have to go through like 6 levels of supervision to be able to go after that person because they're trying to stop DHS officers from being turned in to essentially lackeys for the perpetrators. So so that's what's going on. But if you delay the process of certification, nobody gets into that system, and you're victim isn't protected from that kind of abuse, and that's what's happening. Who's next?
So why aren't our victims reporting? I think you guys picked up on it pretty quickly about the variety of reasons, and they kind of fall into these three buckets, which obviously cross over as well, right? So misconceptions, barriers, and fears. So what's an example of a misconception that an immigrant victim may have, which would prevent them from reporting? Louise.
They think because they're non-citizens, they aren't aware of any rights they have.
Yeah. So I think you just push it once. You don't have to hold it down.
Thank you.
So they have a misconception that they can't avail themselves of services because they're a non-citizen, and services are only available to citizens. As somebody who has picked a jury in Miami-Dade County, a lot of people in our community don't think the laws apply to non-citizens. Yeah.
What I've seen a lot was, oh boy, I lost my train of thought because I did detention. No, oh boy, it'll come back to me. Sorry. Oh, the corruption, where they come from.
Yeah.
There's a lot of corruption, like Mexico or whatever. They come here and they think it's going to be the same here, so they don't trust anybody.
Right.
They don't trust police.
Don't trust
or
pol-
the criminal justice system. Yep.
The criminal justice system. Yeah. So this lack of trust of law enforcement, because from their perspective, law enforcement is corrupt, doesn't care, wouldn't do anything to help them, wouldn't do anything to protect them. Yeah. Do you mind using the mic? Because you had such amazing things to say.
Thank you. I would say one of the other things would be that the fear if I call police, they will take me for being undocumented, or they will ask me about my status, and I don't have protection, basically. So even just starting with reporting, that's one of the misconceptions that they have, that if I call, I'm being taken away. And if I do call, same thing, so.
Yeah, and we have some people that are maybe willing to call because they need help in that moment, but then would not be willing to be involved any beyond that point, because at that point it becomes formal and official, and all of a sudden now I'm going to have myself kind of on the radar, right? Yeah.
Some people who are here legally, through the family sponsor and asylum cases, think that they have to stay with the abuser until they get their papers. So they don't know they can step out and say, or seek help.
So misconceptions about what their status requires of them.
Yes.
Yeah.
Right. And what's interesting here, this is where, as a family lawyer, it drives me nuts. It turns out that if you're working with a refugee family versus an asylee family, it's totally different. Refugees get status, and then they can go along their merry way individually, independent of their husband, let's say, who was the main applicant. They can file for lawful permanent residency and citizenship, etc. If there's a divorce in an asylee family, before the spouse, the abused spouse, let's say, gets a green card, they lose their path to a green card and have to start all over again. So it's not benign, and it's really important to think of how do you safety plan with that family and what do you do? And that's where, connecting them with legal services, calling us for technical assistance is a good example.
Sometimes the barrier is actually even their own family. I had a case where the victim in the beginning was cooperative, and then by the time our victim's witness specialist went to talk to her, she didn't want to. Nothing happened. So she had some communication with other family members that were like, you can't do that because then this is going to happen to them and then your kids. And so sometimes their own family puts pressure on them because of the misconceptions the family has as well.
And that's really hard for us to even know about. Right. So as a prosecutor, I'm just going to look at that and be like, oh, well, somebody, they're not cooperative. And I don't get the advantage of knowing all this back history of what's actually going on and the family pressure, the interfamily pressure that might be happening. Yeah, Kathy?
I just want to say sometimes we've worked with clients who don't even see themselves as a victim, and it's because they may have come from a culture like a machismo culture, or where they felt this was acceptable, so they don't think that they have the right to seek help for this. So one thing that's been really wonderful is when if someone else calls law enforcement to investigate, and law enforcement referred them to us, or told them about the U visa.
Yeah, it happens a lot in your trafficking cases as well, right? That lack of self-identification. Okay.
Can we take one more comment?
Yeah.
One more comment.
No, on the fear piece, I've seen where they use the victim's social media, like pictures of their home, pictures of their kids, and they send them text. If you follow this process, if you report, if you have an order of protection against me, if you follow through, we're going to use these pictures and we're watching you. So it's kind of a fear thing to scare them that we're watching you and we got pictures of your kids and the school and your home. Yeah.
Right, because, we're talking about cases of domestic violence, sexual violence, and there's all of these fears, barriers, and misconceptions for U.S. citizens. And really, this is, just an overlay of what, in addition to all of that, might be happening. So you guys nailed all of our examples, but we wanted to, hold on, let me get to you, Armando.
I just have one other barrier. Maybe we can talk about it later if it doesn't fit in here. But one of the things I've noticed, especially working with people from certain countries, there's so much corruption in their home country, in the government, in the police department. This comes up a lot if you work with Guatemalans or any Central American, actually. They fear the police because the police at home are so corrupt. They know that they're going to help the abuser. They're going to support the abuser. So getting over that fear of the police or mistrust of the police, that comes up because I work for the city of St. Paul, and that comes up a lot. Just getting over that fear, that initial fear, mistrust.
Yeah, and it's not an easy one, right? That isn't like one conversation that's like, hey, I'm not like it is back home. You can trust me. And that trust isn't just immediate, right? It takes a while to build that, and you've got to sort of demonstrate it as well as say it, walk the walk as well.
One thing that I've seen is
I can hear you guys.
witnesses. Are there protections for witnesses? So from a prosecutorial standpoint, you need to prove the case. I have a victim who's cooperative and who's on board and who understands all of this, but the witnesses that I need to get this case to the finish line want nothing to do with any of this because they have immigration concerns. Do these protections extend to them, and what can we do?
Yeah, that's going to be a challenge for you, and there's very limited that's going to be available to a pure witness. But there are some creative things that you might want to be thinking of, especially if there's a level of intimidation or tampering that could get to them where they could be a listed witness.
Before you move on, I just want to say we've seen in the Latino community like a religious fear. I took some vows and I said I was going to be married till death do us part, for better or for worse. So they stay in the marriage trying to make it work.
Yeah, those cultural pressures, and again, that could be also in combination with the familial pressures, the community, cultural, and family pressures.
And we see that in the Hmong. We have a very large Hmong population in St. Paul, and we see that as well. Mm-hmm. And things need to be handled in the family and not by the criminal justice system. Yep.
Okay, so you guys are very advanced. So we are going to kind of get to some of the details that I know you guys are looking to see. So, Tara, why don't you?
No. Do you have the? Oh, here we go. Thank you. Okay. Well, what if anything do you know? What do you know about the about U visas and the U visa process? Maybe just a few.
What I know about the U visa process. What I know about the U visa process is that if they do cooperate with law enforcement, there's a waiting period and then a path to become a legal permanent resident, which we call LPR. And that's like the green card, the resident alien, and that's desirable because after that process, they have the potential to eventually file and become a citizen many years down the road.
Very good, and we're going to kind of expand on some of the things that you mentioned. I will kind of quickly get us back. So just a few basics to just kind of get us started with this conversation. Keep in mind that signing a certification does not give someone a U visa. It's a far cry from that. It's the certification process. Your part of it as certifiers is a very, very small part of what needs to happen for victims. As we've talked about, U visas are really, the whole design of this program is meant to promote victim trust in the criminal justice system, in the police, in prosecutors. It's meant to promote safety and not allow perpetrators to use immigration. Some of these dynamics that we've talked about, it's meant to curtail many of those dynamics that we see. An offender doesn't have to be necessarily a citizen. It can be a citizen. This offender can be a citizen or non-citizen. We do see time and time again, all of the data shows that immigrant victims who have availed themselves to the U visa process or who even have knowledge of the U visa process are much more likely to participate in an investigation or in a prosecution. There is no statute of limitations. I've gotten certification requests for cases that are 15 years old, and I have to really kind of dig in and see what we can find on their level of participation. It can be very old cases. And then last thing, and this is an important thing to keep in mind, that a U visa can be revoked if a victim at some point unreasonably will not provide further assistance that's reasonably asked. And again, we're going to go into what reasonableness means. And you guys know all about the dynamics of these cases, dynamics of domestic violence and sexual assault, dynamics of immigration abuse, and you're going to be really good at that reasonableness part. We had one question?
Yeah, just real quick for the U visa, if the mother gets the U visa, does it get like the children if they're both undocumented? What happens to the children? Is there like a change of status?
Oh, sorry.
They can include any of their children. All of these visas, except for a child who's filing on their own through special immigrant juvenile status, every other case, the VAWA, the U, the T, they can include their children. And children can include in U visas and T visas, I'm looking at Kathy to make sure I get this right, some of their siblings, depending on age and things like that. For children become non-children at some point. So there's, the age of majority kind of matters if you're including children in your applications. But there's no timeline after the crime or the criminal activity by which somebody has to file a VAWA or a T or a U. The U visa, how long does it, so we'll get to that. We're going to get to all that. So we're going to show you a video that was created by the Department of Homeland Security, and that gives you an overview of the U visa.
We appreciate you taking the time to speak with us. I know it hasn't been easy talking about your experiences. Do you have any questions for us?
I don't want leave. You deport me? Boss say I speak with officer, I go.
I understand those are your concerns. Look, we're not immigration officers, but we'll make sure you can talk to someone who can answer those questions for you.
Okay.
Well, today we're talking about immigration laws for victims of crime. We're focusing on human trafficking. We have a panel of experts today from federal law enforcement and state and local law enforcement. Thanks for being here. Let's start right off with human trafficking. What exactly is that? What are we focusing on?
Human trafficking is slavery. It's compelled servitude in which a victim is induced to perform commercial sex, labor, or other services, and they're really being controlled by their trafficker through a variety of means of force, fraud, or coercion. Also, any individual who is a minor under the age of 18 engaged in prostitution in the United States is a victim of trafficking under our laws.
What are the red flags, or what does law enforcement have to try to keep their eyes open for?
individuals who don't appear to be in possession of their legal documents or their identity documents, victims who present as being very afraid, submissive, disoriented, unaware of where they are or their situation. Very similar to domestic violence cases, victims who appear to be heavily coached on what to say. If you have a victim of trafficking who's a minor, they may have been coached by their pimp or trafficker to say that, no, I'm actually 21 years old. Or a victim who is encountered in a factory or domestic servitude to be coached to say, no, they actually want to be there, they're being paid well, they're happy in their work environment and their living situation.
What do police officers need to know before they go into that room? What are they trying to learn, and what are they trying to offer the victims to get the best support and the best help for these people?
Well, we're not trying to reinvent the wheel. We interview people on a daily basis. What we need to know is that we're going to be face-to-face with a unique crime victim that's going to have some additional fears and barriers in place that are going to keep them from feeling comfortable sharing information with us. So I think it's, again, really important for us to recognize our role and get our role out there in the open early on in this process, in this interaction with the victim, that we're not here to worry about your status. We're not here to check your papers. We're here because we're investigating a crime.
I'm sure a lot of these people too are afraid they're just going to be sent back. You know, they're not going to be able to stay in this country. What kind of immigration relief may be available for somebody who's undocumented and they're a victim of crime?
A victim is identified. There's 3 basic forms of relief that they can request or file for in order to assist law enforcement in that investigation or prosecution that's taking place. One of them would be continued presence. Another is the T visa, and the other is the U visa.
Continued presence is the first form of immigration relief that's available to a victim of trafficking who's not otherwise admissible to the United States, so someone who's here and is undocumented. And it's essentially just like it sounds. It allows a victim of trafficking to continue to remain present in the United States, provided that they're a victim and they are a potential witness in an investigation. It is designed to be a tool for law enforcement to keep someone who is a victim of trafficking but also a potential witness in their case around in the United States when they may not otherwise be able to stay here legally. In addition, once they have continued presence, you have not only that short-term form of immigration relief, but you have it connected to other services that serve to support and stabilize that victim.
So you talk about continued presence, and you mentioned the T visa and the U visa. What's the T visa and the U visa? How are they different from the continued presence?
The T visa is a longer-term form of immigration relief that's initially good for up to 4 years. The criteria are that, like continued presence, a victim has to be a victim of trafficking. Victims also need to be cooperating with law enforcement requests for assistance in the investigation, and they also need to be physically present in the United States due to the trafficking or due to the subsequent investigation into the trafficking activity.
Where the U visa differs from the T visa, the U visa does include human trafficking as one of the qualifying crimes. However, the U visa also has many other qualifying crimes where someone could be a victim of those crimes and potentially be eligible for the U visa.
Okay, and is there a place you can find a list of the crimes that qualify for this?
There is. There's actually the DHS U Visa Resource Guide, which the Department of Homeland Security put out, has the list of the crimes, and it also is a great resource for any law enforcement agency. We have frequently asked questions that are in there on the certification process, the list of crimes, what law enforcement agencies are doing when they sign the certification, what they're not doing, their rights, roles, responsibilities. All that's included in that law enforcement certification.
So why is it important for officers to have the knowledge of human trafficking and the immigration relief that's out there to help with these cases? Why is that knowledge so critical?
It's so important for us because we're missing the boat across the country with this. We don't have this knowledge, and we're not identifying these underserved crime victims. We're not identifying these very dangerous perpetrators that are out there in our community. And we're about community safety. We're about victim safety, and we want to go home to our families at night. And so the realization comes in real fast when you start to see the perpetrators that are committing these kind of crimes, that these are dangerous offenders. And if you look at the law enforcement officers that are killed in the line of duty, murdered in the line of duty across this country every year, you can make a connection to a lot of the crimes that this kind of relief covers. So it's a big benefit to us to keep us safe out there on the street as well.
I think we also can't overstate how critical crime victims are to the outcome and success of our criminal investigations and subsequent prosecutions. Victims of trafficking and other types of violent crime have so many vulnerabilities, and one of the vulnerabilities we tend to overlook is this lack of legal immigration status. So if we can address, at least in the short term, the immigration status issues, we can get a little bit closer to a victim who feels safe and secure so that they can embark on that journey to becoming ultimately a witness in the investigation who can be credible and reliable and support the case.
And there's no better feeling when you start the process and identify one of these crime victims and identify and apprehend one of these perpetrators, and then you work together with your federal law enforcement counterparts, and in the end, sometimes you uncover other victims that weren't initially identified at that case, and you take, one or more of these violent criminals off the street as a team effort. And that's what it's all about. It's all about the collaboration between state and local law enforcement officers and our federal law enforcement counterparts that are there to help us do our job.
I thank you so much for all the information that you shared today. And for the officers who are watching, if you have any more questions, if you need to know about more resources, you can go to the Department of Homeland Security's Blue Campaign.
So on that note, we're going to take a 15-minute break, and then we're going to come back and answer more questions and dig in more fully to the U visa, etc. Let's make it 12 and come back at 10:45.
All right, we're going to start back up again. It is. Are you not here? Oh, and I need a clicker. All right. Well, we're going to start digging into the U visa itself, the requirements for certification. So, in order for you to certify as helpful, first of all, we're looking at the victim. It has to be a victim of a qualifying criminal activity. The victim has to possess some information about one of the qualifying crimes. And this isn't something that you will need to worry about. Of course, in order to get a U visa, a victim has to be admissible to the United States or granted a waiver. Again, as a certifier, that's not something that you will be determining. Secondly, the victim has to be helpful. And that is very, very broadly defined. And it refers to someone who has been helpful, is likely to be helpful, or is currently being helpful. And again, that's very broad, and we're going to talk about that in much more depth as we go along. And then lastly, the victim had to, in order to apply for a U visa, the victim had to have suffered substantial physical or mental harm as a result of being a victim. Okay, so what kinds of qualifying activity or qualifying crimes apply? Now, these are crime categories. They're not specific crimes. And so it is meant, keep in mind, these are crime categories that apply across the entire country. So thinking about your own state statutes, many of these will apply to these. Also keep in mind that an attempt or conspiracy or solicitation for under any of these crime categories would apply. So when you think about the kinds of crimes that might apply that aren't specifically listed here, something like a robbery, for example. Robbery isn't listed on the list of crimes, but what could that be? How could you qualify someone who's the victim of a robbery under one of these crime categories? It could be a felonious assault. It could be false imprisonment. In elder abuse, I do a lot of elder abuse cases, and there isn't any specific provision for elder abuse, but for example, financial exploitation may fall under different types of fraud or, extortion. That's the word I was looking for. So get very creative as you're thinking about this and as you're assisting victims through this process. You have to really get creative and try to wedge what the allegations are, what the victims experienced into one of these crime categories. Keep in mind that a conviction is not required. Even an arrest isn't necessarily required. If a victim called 911 to report being assaulted in a domestic assault situation, that may qualify as help as a criminal activity for which they were helpful in the detection. So if law enforcement was called to the scene, the victim later decides that she's not able to participate in the prosecution or the further investigation, that still might qualify.
Can you go back to the requirements real quick?
Yeah.
So just so everyone's on the same page, the requirements, the slide before that. That
exactly.
Substantial harm section of that,
Wait,
so that's not something as certifying officials that we need to have that box checked. You know, we're not determining whether or not they suffered substantial harm. That's not going to be a factor in whether we sign or not. But don't discount it. We still should maybe document some things that can help USCIS come to that determination. So whether it's their condition, any injuries they may have suffered, identifying, you know, what hospital they went to, that type of stuff, so they can gather that information, because they're the ones that actually decide whether or not that box substantial harm gets checked. So we don't use it as something that has to happen, but we still don't just put it in the closet and not pay attention to it, if that makes sense.
Right. Photographs, if you have photographs in your file, that can help. That can really be an important, helpful thing. So who can certify? Many of you in this room are probably certifiers. It applies to law enforcement and law enforcement agencies, both at the federal, state, and local level. It can be prosecutors' offices. It can be law enforcement, any type of law enforcement. Judges can also be certifiers. Unlike judges don't have to have a designated judicial officer on the bench that as a certifier. Any judge can certify. Department of Labor, there's just a wide variety. Child and elder abuse agencies can be certifiers as well.
And Congress created, what happened was they chose multiple certifiers because we understood that in different jurisdictions, there would be times one agency doesn't certify, another one does. We wanted to open up as many doors as possible because we hoped, and the social science data has now shown you, there are slides in the deck that show you this, that once a victim can get through one of those doors, they begin filing protection orders, seeking custody of their children, cooperating in criminal prosecutions, calling the police for help in the future. It begins to open up all of these different doors. And so we intended them to all be open at the same time, and there's no order to it. So a police department can continue to certify from the moment somebody calls 911 forever. And the prosecutor's office, there are some parts of the country where the prosecutor's office certify for everyone, even cases that didn't come to the prosecutor. So it varies all the time. So the prosecutor's office can certify once they start working on a case through any time afterwards. And the same thing with courts can certify in cases that never went to the police or prosecutors. Protection orders, divorce, custody, child welfare cases. Is me? Okay. So basically what will happen is, and I'll just kind of describe the timeline now, and it comes up later on, but somebody files, as soon as they file a case, they get what's called Violence Against Women Act confidentiality protection. That's that red flag that tells DHS they're a victim and essentially hands off. The next thing that happens on the U visa case, and it's it's coming down. It was 5 years. It's now heading towards 4. But 4 to 5 years after filing, they get a bona fide determination, which gives them formal work authorization and formal protection against deportation. So for those victim advocates in the room, whether you're working in the systems-based victim advocates or nonprofits, that's the critical time where you're trying to protect them because they don't have work authorization. Many will decide to stay with their perpetrators until they get work authorization. Then what happens is once they get a bona fide determination, they're waiting 10 years or more to begin to get their U visa. And then 4 years after that, 3 years after that, they can apply for lawful permanent residency, and then down the road, citizenship. So it is a very long process, during which, at many points in the process, they are doing a million different points in the process, they're doing background checks all along the way, so that, true bad guys getting through the process is not easy. And that the people who can apply are both the victims themselves. I heard a question earlier about witnesses, and I kind of want to go to that. So the victims themselves, if the victim is a disabled adult or somebody, who has who's incompetent or incapacitated, or a child, then their parent can qualify or on their behalf. So that there's certain indirect victims who can qualify. Like if you have let's say you have a case where there was a murder in the house of a spouse, and the other spouse, the one spouse was killed, and the other one, called the police for help, gave them whatever information they could about the murder, but they're the ones that's undocumented. They can apply for that visa as an indirect victim of the murder, even though they're still alive. It's another way to think about it. As to bystanders, most bystanders and witnesses who were not the target of the crime themselves don't qualify. The exception is, this was a real case actually in Virginia, and it's in the preamble to the regulations, is there was a birthday party, it was a domestic violence situation. The former spouse came with a gun and started shooting tried to kill his ex-wife, shot other people, and there was a woman attending the party who was pregnant and had a miscarriage as a result of the being present during the shooting. She qualified because she could show substantial harm because she was present when that murder. So that's kind of how you get to witnesses. Who's next?
Okay, so just to break down helpfulness just in a little bit more detail, you can see up here the definition. So the applicant, the person that's requesting this form of relief, has to have been, are being, and are likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing. There's an R between every one of those words. That's the key point, really, in looking at this chart. It's not being helpful from the point in time they call 911 and law enforcement shows up at the scene and they let you take pictures and they give you statements and they go to the follow-up investigators and they go to the prosecutors and they're pointing the finger in the courtroom. It doesn't have to be that. That's not helpfulness. It's being helpful at any one of these points, or likely to be helpful if more information is gathered over the course of an investigation and now we have enough evidence to identify a suspect and then they're going to help us out. That makes sense to everybody? So it really, I feel like I don't want to minimize the importance of helpfulness and understanding it, but it really doesn't require this great degree of what we would consider helpful. So, as an investigator, I want to put bad people in jail, right? And I want to help victims at the same time. So if I wanted to be the Michael Revere helpfulness, it would be help me and do every interview I want. And then when Jane calls you or Tara calls you, talk to them, get on the stand, testify, point the finger, and be sentencing to give your impact statement. That'd be great, right? But we know that doesn't happen with individuals who are documented, never mind undocumented, right? So thankfully, Congress understood that because Leslie was in the room, putting that page of the encyclopedia down, and we have that. So that I really think that this is the most important piece of this process for us as certifying officials to understand. Because if you don't understand it, you block individuals that really need this relief and should have an opportunity to apply for this relief from getting to that point, because we don't think they're being helpful because they didn't testify or they didn't go and talk to me. They only talked to the responding officers. Ma'am.
So just to clarify, if the perpetrator is deported before anything or they go back to their country and the case is just lingering, the victim can still go with this process.
Absolutely.
Because
Absolutely. And that's a great question, and it brings up this relief, all of this is all about the survivors. It's not about us. Again, like Michael Revere wants bad guys in handcuffs and going to jail for a long time. It's not about my case. I'm sorry, you prosecutors out there, it's not about your case. It is about the relief that's available to the victims of these crimes, these qualifying criminal activities. There doesn't ever have to be an investigation that ever even happened. You could be talking to, and this is a fairly common thing. I could be working in the gang unit, the drug unit, talking to drug dealers and maybe people who lived in the home with the drug dealer and find out about a domestic violence incident that happened 2 years prior. And sign a certification for that individual that gave me information about the drugs, but also told me about the domestic violence thing, and not even have anybody to go forward with. Not even have, a case to bring forward to Jane.
And I had a case, just like you were talking about, where we got a warrant for the perpetrator's arrest and he fled the country. That was the first time my client ever got any peace from that guy because he never came back because the warrant was out for his arrest. So there's ways to get justice that don't necessarily fit the square boxes we're used to seeing.
I think I think the majority of people that are doing the work out there in the field that are working hand in hand with these survivors that we talk about, these individuals, right? I think we are at almost a different level of understanding of the dynamics happening within all those crimes that you saw on the slide Tara had up there. So if the right people, that's why it's a designee by the leader in that agency, the chief of police, or the head prosecutor, the district attorney, because they're putting the right people in place that understand. In our agency, we had a bunch of different certifying officials. It depended on the crime, right? I was handling all those special crimes that were under the umbrella of my unit. But, when we had somebody that was involved in a gang violence, shooting, or, maybe it was some kind of intimidation that went on in a gang, our gang unit guys did that because they understand what's going on in the crimes that they were doing. So I don't want to make it a little bit blurry, but I mean, don't make it the heavy lifting thing like I always mentioned. It's very simple. If this person is cooperating at some point in the investigation, they have information. If you don't have anything to go on, but they were a victim of a crime, like somebody walked in with a mask on to 7-Eleven, put a gun to the clerk's head and said, "Give me all the money." Took off and ran away. Well, clerk's calling police, clerk's undocumented, and the guy put a gun to my head and told me to give him all the money. He wants to get an application going. We don't know who the perpetrator is. They had a mask on. We may never find that individual, but that person was a victim of a qualifying criminal activity, right? They have information about the crime. If we have some kind of crazy technology and we're able to follow him and we can see him take off the mask and he can say, "Yeah, that's the guy," and all that kind of stuff, that's great, but it's probably not likely to happen, right? Yes. Did you guys want to pop in? No. Okay, so certifying agency determines helpfulness. There's no degree of time, and I think we already answered that. We talked about that stuff. If the victim has criminal history, that doesn't preclude them from applying for this. Many victims have criminal histories for a lot of reasons that are outside of their control even, right? Because they're told to do things, made to do things, that type of stuff. Did you have something?
You mentioned that your example was he was at work and he's undocumented. Would that go back against him since he's technically not supposed to be work authorized?
Well, what happens is once we sign that certification and USCIS receives it, as Leslie would tell you, now that opens up the door to some protections. They're red flagged. So if somebody tries to go into the system of the federal government and, because they have a phone call that comes in or an interaction, it's going to come up in a red flag. No, this person is under the U visa certification process. Their packet has been, received and reviewed. It meets the standard requirements, investigation ongoing, whatever that type of
I think that's great, like forward thinking, Jason. But yeah, you're asking about, does he get dinged for doing something illegal before he asked for the visa, right? And so that kind of falls into the category of what they're going to look at with the victim. We get this a lot. This is a frequently asked question, which is, what if the victim is not perfect? Hey, has anyone had the perfect victim? So what if the victim's not perfect? And so, again, that's not something we're ever asked to be a part of. We're not asked to look up the victim's criminal history. We're not asked to go do a deep dive into their work history or their immigration file. That's USCIS's job. And so, again, that's part of the don't make your job more than it is. Your job is to answer a couple of questions. Are they a victim? Were they helpful at some point? We do, and you don't have to not do it. Most places do run a criminal background check on the victim before signing. I'm just putting it out there. I think most places do. And so then the idea is, what are you going to look at that, right? So if a victim of domestic violence has some shoplifting on their record, what do you think that means? They were hungry. Yeah, right? We know that financial manipulation, immigrants, we know that's part and parcel of it. I once trained somewhere and they said, yeah, if somebody has a criminal history, we're not going to sign their U visa or their T visa. And they were not signing victims of trafficking who had histories of prostitution arrests. It basically makes it, it's not going to be useful at all. So that's not our job. That's somebody else's job. And we recognize that there's lots of reasons. Now, if a victim comes in and has a massive criminal history of murder and gang violence, which happens, but even if they qualify, you can never be forced to sign it either, right? So this is discretionary. But just have that trauma-informed lens when you're looking at things like that.
And I was 16 of A, B, and C, but now I just happen to be a murderer, gang member, and some of the most violent things in my community. Can you sign this? No.
And Congress, basically, when we wrote the statute, we created waivers that the Department of Homeland Security has discretion to grant. So when the domestic violence victim shoplifted baby food to feed her kid, we're going to waive it, and they do waive it. When the gangbanger, who was a child abuse victim, tries to get a waiver, they don't. That's kind of how it works. So that you don't, so a lot of victims with criminal histories will be eligible and will be able to get waivers, particularly where it's related to the abuse.
So just wrapping up this section, and I know we get a couple of quick comments as well. These are some of the things that can be examples of helpfulness, but the sky's the limit on this. Any time that they fit in that category that we talked about. I know Tara mentioned the 911. That's a very simple one. And when you talk about domestic violence cases, which were about close to half of the U visas issued, right? Somewhere around that. How many survivors, victims who call 911 and have officers come to the house, tell them some things, even let them take photos, but the next day when I call, one of the guys that worked for me calls in the unit, they don't want to talk to you. Or they don't go to the hearing date that's coming up because all the things that we know. Now add the fact that they're undocumented and they have all those fears and all those things. I'm going to lose my children. When I get deported, my family back in Mexico is going to get injured if I cooperate against this guy, right? All that stuff that happens. So that's why it's not about our case. It's not about the case going forward. It's about were they a victim, were they helpful? And that's, just saying, yes, that person did that to me. Hey, can I take a picture of the marks on your neck? That's helpful to me. I'll sign that all day long. Now, I'm not telling you USCIS is going to give that visa every single time. They have, and I think that's what I'll wrap up with. I think it's important for us in the field because it changed it for me. It was like a before this and an after this in doing this work. When Leslie and I spent some time up in Vermont, at USCIS, talking to the adjudicators, talking to the individuals that have their fraud unit. We spent some time there and we got in the room and we did some training. And I felt so confident leaving there that I do my not heavy lifting job. It's almost like a restraining order application. You have to have some things in place before you bring it to the judge, right? Are they family household members? Were they, abused, that type of thing? It's the same thing. We're kind of like checking off the boxes, making sure this fits. We have the information that we can gather and we're passing it off to them. And they do an unbelievable job. Yes, there's fraud that happens. It's minuscule, right? It's okay that I think, in my opinion, very, very minuscule. They have a fraud department. You guys mentioned charging and everything. There's people that are out there signing our names, certifying. They find it. Like they're really good at what they do. So have confidence in that step, in what they do, and just let's leave that light lift, that kind of siphoning things out for us to do in the field to start the process to protect victims and get eyes on those violent offenders like we mentioned in the video.
And this is where I like to bookmark it back to that first thing, which is what is the intent? The intent is that larger community trust and all of that. So that's why we say victim-centered. Look at it from the victim's point of view, not your case. And so I think you had a great example. What if the defendant's deported? I had a lot of cases in Miami where first-time offenders for domestic violence got put into diversion. That case was technically still open. We had people that didn't want to sign the U visas because they didn't want to sign it until their case was done. And that's the wrong attitude, right? Because at the point, the victim is still being completely at risk to that offender. I am making them more at risk than the offender did if I'm not signing that. So if we look at all of these things, conviction, whether the offender is identified, those are not the questions that we're supposed to be asking ourselves. So, for example, victim of a sexual assault goes to the hospital and has a rape kit performed. Nobody is found. CODIS has no hits. Does that victim get her U visa signed? Do we wait until there's a hit? No. And when that U visa is signed and when she has that relief, and 5 years later that CODIS hits happens, what do you think's going to happen? Where's our victim? She's with us, right? We've helped her, we've made her feel safe, and then we have that. So that's the thought process behind it. So every time you start feeling like, I didn't get my conviction, I didn't get my arrest, go back to that intent and look at it through that victim-centered point of view.
Yeah, you're increasing the likelihood that you're not going to lose the victim's participation if you sign early and build that trust early. I can think of a case that we had not too terribly long ago where the neighbor had called 911 and reported a domestic. He was arrested. The victim the entire time was not willing to participate or answer calls or do anything whatsoever. She through a community advocate, was able to secure a U visa or do a certification and apply for a U visa and get that protected status. And later on, we ended up ultimately resolving the case as a disorderly conduct, but she showed up for the sentencing and gave an impact statement at the sentencing. So, I mean, at any point, you may catch them and you may build that trust and they'll come back. And then the likelihood that she's going to report being assaulted again, if and when it happens, is much higher if you've done that certification.
Can you take a minute for a little question? Yeah.
I have a question about attesting to helpfulness. We have certain cases that come to us that are from outside our jurisdiction or within our jurisdiction, but that we never touched. We're the county attorney's office. Never became cases. We have no idea exactly how helpful it was, but we can read a police report. We can see helpfulness. I'm just wondering what the best practice is if something happens outside of our jurisdiction or even within, whether we should defer them to a more appropriate certifying agency or whether we should sign it and how that might affect them down the line.
Yeah, so Leslie mentioned it was written in that victims can forum shop. That's part of this because there are some places in this country, I'm sure you cannot even believe it, Eder, that will not sign these under any circumstances, right? So they're allowed to do that. So your standard to sign it is the standard that we use in immigration court. Does anyone know what that standard is? It's not beyond a reasonable doubt. I'll let you know that. Anyone? Yeah, so it's reasonable suspicion or any credible evidence. So it's a pretty low standard. So if you feel like you have that based on your review of the written reports, you can sign.
USAS will be calling that agency and asking for questions.
Yeah.
Do you have any advice?
Do you mind using the mic?
Where defense counsel for the abuser weaponizes all of this, and
so that's our last little bit that we're going to give you. We're making you just wait.
That's the president of the bowl.
Early, you have to stay.
Thank you. So yeah, and DHS in their regs, they say take this victim-centered approach. It's from that, and they talk about the fact that this stabilization is part of what we expect in these cases, and that it's going to help us down the road. So they also promote the use of qualified interpreters so that we get the best information we can. Okay. How does this help us?
I really think that we covered this.
Okay.
I think in the interest of getting to that present and unwrapping that bow and all that, I mean, we talked about the benefits. I talked about the story with the gang member and the sexual assault case that we uncovered because of that incident that happened at the restaurant. So there's a lot of benefits, and we're having more victims cooperate. We're putting more bad people in jail, and we're keeping our community and ourselves safe. So I think that's the message behind those two slides. You can see the bullet points there, and I think that what you're about to say is really important. I want to take the time up on that.
Okay.
Yes. Oh, I got to talk about the resolution too. All right, in that case, give me a chair. We'll talk about this one. No, this is just really exciting, and we're seeing more and more individual agencies really hop on and get these things put in place. In 2018, the International Association of Chiefs of Police, they were the first ones, Leslie, that actually put a resolution together to recognize UNTVs as a significant crime-fighting tool, i.e., right, getting bad individuals out of the shadows, off the streets, and protecting our communities, all like our mission statement of every agency across the country, police agency has, right? So it supports the communication, the training, the development of policies that address U visas, T visas, immigration issues that arise in our investigations, as well as the other things we talked about. So collaboration is key too, right? And I think the last thing I'll say, since you did give me the mic back to talk just a little bit, we've already kind of talked about this just a little bit, but I just want to speak to the law enforcement officers, really anybody that's under the umbrella of a law enforcement agency. We are the federal government to these survivors that are out there in those shadows. I mean, I was plain clothes for a long time, but you're wearing a powder blue. The sheriff's department might be wearing green or brown, right? The state police might be wearing a different color. Doesn't matter what color your uniform is. You represent DHS. You represent the federal government to those individuals because they don't understand, like you gentlemen mentioned, the whole system. So it's so important for us to collaborate with everybody, like the people in the room, and to get out there and educate the community, identify the leaders in those communities, and get the message out that we are welcoming, that you can come to us. You can call the police when something bad happens to you, and we are not going to ask you your status and call the feds and get you deported, that type of thing. You're going to see a lot of things happening when you get that message out there.
So helpfulness kind of happens in two pieces when you ever look at one of these certifications. So there's that initial ask of, were they helpful? Are they being helpful? Are they likely to be helpful? That's almost universally going to be a yes if it's on your desk, because that means that somebody called police, somebody filed a police report, somebody did something. So helpful in the detection of a crime is one way to certify that initial helpfulness. So that's not as I think difficult as sometimes the second question, which is when they ask, was there at any point a time when the victim unreasonably basically became unhelpful? So that is they called police, we've got a case, now we're set for trial, and now they're refusing to come to court. That's really where the rubber meets the road, and that's where most people have the difficult kind of way to process, okay, now it's unreasonable that they're not coming forward, they're unreasonable that they're no longer answering my phone calls. So why does that happen? Tara, has it ever happened to you?
Never. It has never actually happened to me.
She's
I've
like,
had
so
100%
nice.
participation of all crime victims, so it's really worked out great. But when you are assessing whether it was reasonable for a victim to do that, to decide not to participate in, and I never use the word cooperation. I like the word participation. Just has a better ring. Cooperation sounds like they're doing something they're not. They're not doing something they should do. And what do we know about the dynamics of domestic violence and sexual assault? What do we know about those dynamics? When you think about reasonableness, whether it was reasonable for a victim to not answer your call, to not come in and testify, to not come into the sentencing. Thinking through those, I think once you really think through that lens, it really flips the reasonableness really on its side, right? And you realize that really anytime a victim isn't participating in the prosecution, the likelihood that they're being subjected, we know that intimidation and manipulation is near universal in domestic violence cases. Whether we know about it or not is a different issue. And I would suggest that one thing that we've done in our office is that we have a handout that we'll give when a case first gets charged, and we're sending them a bunch of information about victims' rights and things like that we're all mandated to do. We also include something that talks about, here are some messages that you might hear during the course of this case. You might hear, I'm going to jail for a really long time and this is your fault. You might hear, you kind of list all of these, and we actually have them in quotes, and we have them in different languages. And so that victims know to expect these things, and they know not only to expect those things, and that those things are designed to make them not participate in the prosecution, but they also know that those are things that the prosecutors and law enforcement are interested in hearing about. Because if someone says to them, if you come to court, I'll take the kids away. Well, they don't think of that as a crime necessarily that needs to get reported to law enforcement. But if you're proactive in your work with victims and let them know that to expect these kinds of tactics and that we want to know about that, that can really make a difference. But then you also have to do a lot of safety planning around that as well.
So what do you see?
So my question, I think, relates to a case that we're actually looking at right now, where a domestic survivor, had filed a report and we charged a case, and then following that offense, they were actually still living with the abuser, and then ended up filing a subsequent police report with a different jurisdiction like a month or so later, and then became cooperative with our case. Interestingly, though, my question relates to the fact that I guess like if USCIS is to look at the police reports and everything for this case, they will likely see that the victim had like declined to sign a medical release and a search warrant was needed for that. And so I guess I'm wondering, to what extent do moments of a lack of cooperation kind of affect like a U visa adjudication, despite maybe other evidence of cooperation and, you know, things changing?
Yeah, so they're going to really heavily rely on your determination. So if you don't think it's a problem, USCIS is probably not going to think it's a problem. What happens more often than not is that you say it's a problem, and they're trying to fight USCIS and say it really wasn't. I was cooperative enough to do this.
I don't know the reason why. The whole word is unreasonable. Was it reasonable for her to have fear as why she wasn't doing something you wanted her to do? So I think that's the key. Like, would it be normal for someone to have a fear and not want to do that for a lot of really good reasons that we maybe don't understand fully because we're not in their shoes? I mean, that's what I always did when I was looking at.
And then what's going to happen in that case is, first of all, they receive training. They receive domestic violence, sexual assault training. They understand the dynamics, and they'll see that they didn't cooperate, and then they did cooperate again, and that whole history. And they're used to seeing it. But they'll also, if they have a question, they'll issue a request for further evidence and give the victim an opportunity to explain, he locked me in my house that day and I couldn't show up at the hearing, or whatever the story was, whatever intimidation was going on. And they know that, I think it's over 30% of VAWA self-petitioners and EU visas continue residing with their perpetrator until they get work authorization. And they see that in their cases all the time. And the amount of influence and control the perpetrator has in that situation is well documented. So I think you go ahead and do the certification, and then the whole piece, it's going to come back. It's 4 years later, they're looking at this whole pattern. So the pieces will connect, and often do.
And keep in mind, too, I know that in Minneapolis, and the same as in St. Paul, our cases are taking forever to make their way through the criminal justice system. So I think we can expect that a victim is going to, at some point, drop off. The incidents of that we've seen of victims being willing to participate in the process from the very beginning all the way a year and a half later, some of our cases are taking that long to get through the system. Really consider those things when you're thinking about reasonableness.
I don't know if this is deviating too much from the question, but my mind keeps going here. So you don't want to assume that someone's illegal, and you guys, like you said, you don't ask what their status is to not kind of push them away. Who do law enforcement or prosecutors how do you know who to give to? Are you guys just giving this to anyone that has, for example, Spanish last name, Spanish, Latino last names, or do they? Because if they don't, how do you open that door to begin that conversation and to see if they need this certification? Because if they don't know about it, they're not going to ask about it.
Yeah. What role are you in? Just out of curiosity.
I'm with the City of Minneapolis Prosecutor's Office.
Okay, yeah. So normally I would not be giving this advice to a victim that I was working with. I would rely upon the victim service providers that worked within my office. And there are those ordinances that we talked about where you can't really just ask somebody that. So there is that sort of back way that you'd get to those questions. If you're a victim advocate, you're probably asking about safety, about any fears, and then maybe a victim might disclose that a fear that's related to immigration, and then they might say, okay, well, let me go ahead and give you the access to this information. So there is kind of a dance that happens, and it's not just, anybody with a Spanish last name I'm signing a certification for. That's not how that's working. It needs to be requested.
Can just one, and more broadly than that, keep in mind when we had the state statute up, one of the things that's required with that is community outreach, and that's an important way. I mean, that doesn't specifically answer your question, but broadly, that's work that we all have to do. Everybody in this room can be involved in with your MDT or other collaboratives in work and just getting the word out there about this remedy.
And there's other ways of doing it. Your courthouses, your waiting rooms, you have brochures in multiple languages available so that people can, like, just in the waiting room while they're there, pick up something and learn. There's ways to, as Jane said, ask but not ask. And also don't assume it's about last names, because you'll miss me, right? So and you don't, because you never know. If it's, because you might be dealing with somebody who's a U.S. citizen, but they're 17 years old and they have an undocumented mom who could be your star witness. And so you want to get the information out there, radio, brochures, things like that. Give it to everybody. Because everybody, how far removed, you could say, I don't know if this applies to you or not. We give this to everybody. We give the brochure about U visas to everyone. And you're going to reach their sister, mother, cousin on some other case if it's not that one right now. So there's no harm in giving it to everybody. You don't want to, you could insult a U.S. citizen, Latina, Spanish, who speaks Spanish and English, and you don't want to get her pissed off at you and not want to cooperate. So you've got to think of a way to do it in that respect.
So I just have to throw something out there, and if I'm wrong, just say, all right, stop, you're wrong, it can't happen. But one of the most important collaborative relationships that I ever had in my work was the community advocates working at the shelters, working at the centers, and that type of stuff. So if you're an advocate working at the domestic violence shelter, you're not allowed to ask and talk about immigration status? I think you are, right? Oh, the advocates. So, I mean, the work can get done for us like that. I mean, I have a domestic violence victim. I don't even have to think about asking that, because I'm going to refer them to the advocacy people in the community who are going to get that done, and then I'm going to find out about it, and then we're going to. So anyway, I just think that that's important to know. There's individuals out there in the community that can bring that information to you as well.
So what happens is, let's go back to so helpfulness for certification and ongoing cooperation are kind of two different things. You have to have we've talked about the amount of helpfulness and that it can be a very small amount. And then once somebody files their case, there's an ongoing requirement for cooperation and ongoing assistance. So what happens is they'll get a bona fide determination, or they'll file their case, and then they're still supposed to be cooperating unless they can show that their non-cooperation wasn't unreasonable. And that goes on forever. So what we found, though, is that as the case moves further on, they get more and more cooperative. And that some of the research shows that like 70% of U visa victims actually down the road, once they get work authorization and all of that, become cooperative. And another huge chunk of those will say there wasn't anything to cooperate with because they haven't gotten a hit on the sexual assault test yet. So over time, they absolutely do become more cooperative. They absolutely do make further police reports. And that, once they're in this pattern where they get the bona fide determination, they get stabilized, and then there's like a 10-year process or more. And so they're renewing their work authorizations and doing this, and they're cooperating, and they're bringing other victims for help. So.
My question might be a little bit off topic, but I don't know if we're going to get to this point, so I thought I'd ask. Does the victim need to be in the U.S. in order to apply? I've heard of situations where a lot of people have been a victim of a crime and they end up just leaving the country and going back to their home countries. Is that something that they can do, so apply out of the country? And if so, would they just go through the same process, or is there something else that's required for those individuals?
So I'm going to answer this, but I'll look at the immigration attorneys in the room, make sure I get it right. So yes, you don't have to be in the United States to file for a U visa. So you can file from either U.S. or abroad. The problem is the mechanism for being able to re-enter the United States can be complex. You need a good immigration attorney who works for you on that. And it's going to take many years. So if you leave and apply from the outside, you're going to be outside the United States for quite a while waiting. I get that right, Kathy? Yeah. Okay.
I just wanted to know it's different for T visas
Yes.
than for U visas.
Yes.
T visas do require presence in the U.S., whereas U visas don't.
Correct.
Great thing to mention. And that's one of the distinctions. Overall, we heard the video about the T visas and continued presence, so we're not going to do a deep dive today on that. Overall, we always recommend, if you qualify for a T visa, to apply for the T visa because there's no waiting list, and the processing time right now is about 18 months, last I heard. Is that kind of consistent with what you're hearing?
It's about 18.
Yeah, probably around 2 years.
Okay. It's getting better and better. So if you qualify for a T visa, you want to do that process. But there are a couple of distinctions, one of them being you do need to be in the United States to apply for the T visa. And you have to show that there'd be a hardship to return to your home country. So there's a couple of things you want to make sure you know the distinguishing pieces of it. The unreasonable requests. So this is one of the things that I hear more often than not, which is I'm not going to sign the U visa till my case is over because I don't want to ruin my case and all of these things. But what we know about it is that if you've signed the U visa, you have if that's signed and you've applied, you have an ongoing responsibility to cooperate. So if I'm looking at a victim that I want to come to show up for trial, is you think it's more likely that victim shows up if I've got a dangling carrot and maybe one day I'll sign, or I've signed and I could revoke at any time, right? So we want to be thinking about that because the timeliness of certification is so key. We saw the timeline. We saw the fact that sometimes there's these benefits and these fears can be alleviated once that certification is signed. We don't want to delay on that piece of it. So I wanted to go for that before we get on. Okay. We know about witness tampering, all of these types of things. I think we want to go into the prosecution piece. Okay, we won't wait for them any longer.
There's a lot of good information in the slides just to look at, some charts and stuff that you'll see.
Okay, so we are going, oh my gosh, this is a lot, okay. Okay, this is where we're going to start. I don't know what page that is in your materials, but you'll see the cute graphic pros and cons, right? So we talked about all the pros.
Page 40, yep.
Yeah. So what are those pros, Tara? What's good and what's scary?
What's good? What's good is that it establishes trust, victim trust. Isn't that the number one reason why a victim may be willing to talk to us in the first place, much less come in and participate in the prosecution in any way? So building trust is really an important one. Building rapport, which is kind of part of building trust. Protecting them from the offender. Leslie talked about the flag that happens, the vow of confidentiality, and how once they've applied for a U visa, the perpetrator can no longer say to them, "Well, if you go in and testify, I'm not going to sign for you. You're going to get deported." They can no longer use those dynamics, and the victim knows that by participating in the U visa process. And of course, they're protected during that time. Once they've submitted that application, they are protected from deportation and are here to participate in your case.
And often have access to benefits and work authorization. So all these things that are making those fears, barriers, misconceptions, all of a sudden we're able to bring those down a little bit. But what's the elephant in the room? What's the fear?
For you prosecutors, what are you afraid of in signing a U visa before your case is done?
Yeah.
Exactly.
What's the first thing the defense is going to say and do, right?
The only reason you're here testifying is because you've applied for a U visa or you know about the U visa program, right? So with really, the case law in Minnesota is actually very good on this. Unfortunately, we don't have very many published decisions, although we can still use them when we're making our arguments, right? Our unpublished decisions. So the case law is really good on these points, and really with I think somewhat minimal effort, but with just being kind of knowing how to navigate this, we can actually turn this very small challenge into a strength in our case. And so
And that's often what we're challenged with as prosecutors, right? Remember I said, does anyone have that perfect victim? No, right? So we're always challenged with what we know the defense is going to throw at us. And our job as prosecutors is to turn those challenges into strengths. And so this is just one more thing that it's our responsibility as prosecutors to do and not the victim's responsibility to do for us. So one of the things that I like to do is really analyze my case. Juries don't like cases that are overly sanitized or a case that is presented in a vacuum. Sometimes that makes us feel safer. We want it to be clean. We want it to be neat. And defense attorneys often try to also minimize what we can talk about because they know juries don't like it when they don't get the full story, right? So in a case of a domestic violence case, you might be there because of something that happened in the course of 5 minutes, right? Somebody pushed somebody against the wall, held their arm against their neck, maybe hit them, right? Those acts of domestic violence, the actual crime that occurred, takes how long? Moments, right? But what do we try to tell the jury, the judge? Do we want to focus on those 5 minutes? No. We want to tell the whole story so they understand the context, the nature of the relationship. So that's part of our job to do that in any case that involves these complex dynamics. So we always want to be looking at the overall picture of the case, and no different from these cases that involve a U visa or an immigration element to them. So one of the things that might be really important for you and that you as a prosecutor, you as an investigator want to get evidence of is, why did the defendant pick this victim? So what are some examples of what victim selection might look like? Okay, a family relationship, tell me what that might be. Like, I know this person won't leave me because there's a greater family relationship here.
Yeah, there's a family dynamic, like they're a member of the same family or connected in that way.
Okay, so they know that that's going to make everything a lot more complicated when people know each other and they know each other's family and they know each other's friends, and it's much less likely that you're going to go to the police and all of those things because it complicates things. What else? Their immigration status, right, makes them incredibly vulnerable, easy to control, and probably easy to escape accountability, right? So victim selection can be very purposeful. So it might be, did the offender choose this victim? We see that with U.S. citizens who choose victims or choose spouses that are not. There's a control dynamic in a lot of those relationships.
We see that in sexual assault cases as well.
Yeah.
A lot of the child abuse cases, we see that.
Yeah. We had a case in Miami-Dade County. If you're not familiar, in the southern part of the county, it's very rural, and there's a lot of agricultural workers, many of which are undocumented. We had a case where somebody was robbing workers that had immediately as they exited a cash checking store. You've had the same thing, Enrique? In Minneapolis, same thing. Why do you think that robber was targeting that cash checking store on Friday afternoons in a place surrounded by nurseries and agricultural areas? Because everybody's getting paid, and what's the likelihood those victims are not going to report, or if they do report, they're not going to be continuing to participate because of those fears and everything. So they're targeted because of those real or perceived vulnerabilities.
And in workplace cases, the sexual assault perpetrator who becomes the crew boss on the farm, in the farm worker case, or, in the meatpacking plant or something like that, where they know that the people that they're going to be supervising are going to be potentially undocumented, and they can use that to get them to be silenced about the sexual assault, and they target them for that reason.
And so as a prosecutor, Tara, are you going to want to be talking about that in your case?
You are, because it's your theory of the case. So it's really important. And what are you going to want to do? You're going to want to educate the judge, the jury, through voir dire, through direct examination, through pretrial litigation. That becomes part of your theory. And so, yes.
Yeah. Now, the criminal act itself may involve information about the immigration status, right? So the criminal act of stalking or harassment or even domestic violence, what do you think those threats are about? We're going to be talking about that in our case. We're not going to be sanitizing that case. If it's a human trafficking case, a forced labor case, a case where there are foreign national victims, that force, fraud, and coercion is most likely going to be about immigration status. So we're going to need to talk about it in those circumstances. So instead of being on the defensive, we want to think about how we can be on the offensive, talking about these things up front. And lastly, the other one is to escape accountability or escape detection. In this, we want to position our offenders as those folks that are being intentional about who they're picking, what they're doing, and why they think they can get away with it. I loved picking juries and always talking about this dynamic from the outset and trying to instill empathy in the jurors so that at the end of the day, I could say something like, this defendant picked this victim because he knew she was vulnerable. And he threatened her because of those vulnerabilities that he knew about. And he also thought he could get away with it because he thought no one would believe her and he thought she wouldn't ever go to the police. What do you think my jury wants to do in that moment? They want to be the one that believes her. They want to be the one that proves him wrong. And they want to be the one that stands up for her. So you got to figure out how you shift those dynamics because they are picking somebody that they don't think will ever go to the police to begin with. If they go to the police, they won't be believed or they won't continue to cooperate with police because of the risks there. And then they continue to threaten them with that witness intimidation afterwards as well. So that's your first kind of attack, your first strategy session there on analyzing the case.
And I think that applies if you think that that it's relevant, right? If you think that there's a likelihood that this is going to come in. But we also want to talk about strategies for keeping this out because there is, like I mentioned, there's some really good case law that sometimes often immigration status has no business being discussed as part of the case. You may not have all of this information about prior intimidation based on prior selection of the victim based on their immigration status. You may have very good reason why you don't want any of this information in.
Yeah, like that, robbery of the 7-Eleven where the victim's immigration status is absolutely irrelevant, then you want to be thinking about this strategy, right?
Right. Because the defense sometimes they just want the jury to be what? Prejudice against the victim, prejudice that they're an undocumented immigrant, and so really sometimes that's really the only theory that they're going on, and so you as a prosecutor need to be in front of that.
Yeah. So the arguments are sometimes that it is completely irrelevant, and you're not going to talk about it, and they're not going to talk about it, and your idea is that it's either minimally irrelevant, that the probative value is substantially outweighed. And some of the examples are when there are child victims and the parent is applying for the U visa. And there's no evidence to suggest that that parent has any reason that they're motivated by this, right? So child victims, a couple of other cases where courts have found, this is completely irrelevant is when there's such a time lapse between the reporting of the crime and the request for a U visa. That's also another place where courts have said, this is just completely irrelevant.
Right.
Here's a case that we talk about, which is basically the court saying, it was so collateral, it was so outside of the status, and that also by bringing this up, you were questioning the defendant's immigration status. And that, of course, is never going to be allowed by the court. So it gets dangerous there, too.
Yeah, I think courts seem to be onto this notion of all you're trying to do is create bias against this victim. There really isn't any probative value, and we're seeing that in the case law.
This is your brand new case.
This is just a few weeks ago, and I believe it is a Hennepin County case. It was a sexual assault case, and oh, sorry. Okay, what are you doing? And the defense tried to bring in evidence that the victim knew about the U visa process. There was an offer of proof, which is something that you'd always want to do if you're trying to keep it out and they're trying to keep some immigration information, get that into evidence. You're going to want to make sure that they're giving an offer of proof as to what's the information, what are we talking about here, what evidence do you actually have of their bias, and is it something that's even admissible? But so in this case, both the child and the mom knew about the U visa process. Actually, allegedly, the defense said, well, I told them that they could apply for a U visa. The defense also wanted to call an expert witness in the case to talk about the U visa process, basically to say, yeah, it's an incentive for victims to lie, is basically what they were trying to do. So the court just didn't buy it. During the offer of proof, there just really wasn't enough evidence to suggest that they knew at the time that the child made the report. And that's really the key thing. And I think that's where often we're able to get this stuff excluded. Because if at the time they reported the crime, there isn't any evidence that they knew about a U visa, excuse me, that it's just not relevant. And it's certainly not probative of guilt. Yeah.
What we want to is the most people that we can know about this. That's the way that we actually protect people. This is U visas and T visas are just why, known by the communities and community members. So how is that will be something relevant? Is the thing.
That's a good point. The court also did find that, well, they may have known about it, but even if they did know about it, which it didn't sound like they believed that they did, they never applied for a U visa. Although I'd be careful. I think we can still make the argument that that shouldn't be the litmus test as to whether it's something that's admissible or not, whether they actually filed a petition.
And you've picked up exactly what I'm afraid of when I read this case. I'm afraid that somebody's going to take this and say, we got what we wanted because the victim didn't actually know about the U visa, so therefore we shouldn't tell victims about U visas. So my fears are in valid place. And I think that's why we talk about all the other strategies as well, because the strategy can't be don't tell victims about U visas and then we'll never get in trouble. The strategy must be that we just need to be strategizing as prosecutors how we're going to deal with it and not make it the responsibility of the victims and not put victims in more danger by not telling them about it and not giving it to them when they apply for it. That's got to be the takeaway. But the way that the courts think about it is interesting. And in this case, what the court said is that there's very minimal evidence that this was something that motivated the victim, and that even if there was some minimal relevance, it was so outweighed by the prejudicial nature that the courts really went to that piece of it, which is that prejudicial nature of it. Now, of course, you are going to have some victims that know about the U visa and that have applied for the U visa. So then we've got to go to our other strategies, which are often things like, let's make it part of our case, let's educate the jury, and let's talk about how the offender weaponized the immigration status and how this U visa is something that the victim deserves because of this weaponization. So we've got to be ready to be flexible with how our case comes to us.
Yeah, and I just want to say, one of the things that bothered me about the case is the fact that somebody files for a VAWA self-petition, a U visa, or a T visa is essentially confidential. So there's a federal confidentiality law that protects information about the existence of the cases, what's contained in the cases, and Jane and Tara are going to talk about the one exception, which has to do with what's in the prosecutor's control.
Yeah. So those protections are really important in family court, more so than in criminal court, to be honest. Yeah. In criminal court, number one, your defendant is probably going to know if they applied for a U visa, if it's a domestic case. And number two, if the law enforcement or the prosecutor signed that certification, then it's something that we need to provide in discovery. So in a criminal case, we have less protection of this sort of confidentiality that VAWA otherwise provides to victims that have applied. So it's on us to think about, okay, how are we going to talk about this from the very beginning? How are we going to talk about it during jury selection? And not thinking about, I don't know, hey, is anyone here prejudiced of people that are undocumented? That's probably not the effective way to do that. You might get an entire panel that says yes, because they think they can get out of jury duty that way. So you've got to be strategic. Equitas does have some resources about developing voir dire or jury selection strategies based on your court's procedure. So that's a place where we want to start. And then, yeah, what other?
I just want, before we moved on to the next part, I just wanted to, I pulled this language from the one court, or one of the decisions that is published in Minnesota. The language that they use is, and that keeps getting, I'm seeing it repeated in all of the unpublished subsequent decisions on this point. And it's the State v. Larson case, which is actually a 2010 case, but it said the evidence must not be so attenuated. I was looking for what was the word that they use all the time? They keep attenuated or minimized so as to be unconvincing. So anyway, I just throw that out. The State v. Larson case is probably the one that we're going to cite the most when we're trying to keep this evidence out, and then all of the cases that get cited subsequent to it.
Yeah. So. And then during direct examination, right, we don't want to wait until the defense does this on cross. We want to talk about it. We want to talk about all the immigration-related abuse, and then we want to talk about how they learned about the U visa, and talk about, is this why they're lying? Is this why they're saying this today? Why are they here? Just like we do with anything else that potentially the defense is going to use to impeach our victim. So we take the sting out of it.
Yeah, and in the case that we just mentioned, the case from a few weeks ago, the defense was going to bring in an expert as I mentioned, to talk about the U visa program, with the idea of sort of selling it as this is a reason that victims might lie. But you as prosecutors, and in that case it was excluded, but that's only because the other evidence was excluded. I think then it really wasn't relevant to bring in an expert. But as prosecutors, just like we would bring in an expert witness to talk about the dynamics of domestic violence, you could bring in a social science expert to come in and talk about the dynamics of domestic violence that might be unique to immigrant victims. Some of those that we talked about earlier this morning, there are a lot of unique dynamics that probably aren't within the jury's common understanding. And then also just to talk about the U visa process or the U visas itself, and kind of what they're meant to do. It's really a way to get some very good information and education to the jury.
Yeah, because the defense, if you don't talk about it yourself, the defense is going to say this prosecutor gave this victim citizenship. That's what the jury's going to hear from the defense. And so you've got to be prepared to actually kind of break it down and say, no, the law enforcement signed these 4 questions. Let's talk about realistically the whole process. So you don't want these myths and misconceptions to get blown out of proportion. So you do have a discovery and due process obligation to provide information to the defense if in fact a certification was requested or signed. So this is a big thing where I've seen prosecutors not sign, thinking that they then don't have to give it in discovery. But the motive to lie and the bias, that ethical obligation for us to turn it over, when does that arise? As soon as they ask for it. So then there's no point in not signing it at that process, because you've got to turn it over that there was a request, so you might as well sign it, you might as well deal with it down the road. So the only thing you should have to turn over is the certification itself. And another reason why we don't want immigration attorneys giving us 700 pages of request for the U visa certification. We used to do that too, because in Miami, the practice was not to sign it as easily. So what we found ourselves happening is that immigration attorneys were trying to sell us on signing it. So they were giving us affidavits from friends and family, and they were giving us medical records and counseling records and all of this information to get me to sign it. Well, that also made all of that information discoverable as soon as it came into my hands. And so if you're working with immigration attorneys that maybe aren't as skilled and knowledgeable, you may even want to say to them, like, listen, I don't want anything other than the certification and maybe a cover letter. And that's all you really want from the prosecutors and law enforcement.
And our Brady obligations do are such that we are going to have to disclose the certification request in and of itself. But what if if you're, and again, we've got to talk about this with in our MDTs and educate the immigration lawyers on don't send us all that stuff, or other people who are sending us certifications. But what if they do send you all 70 pages of the application itself and all kinds of information that you wished you didn't have, but you have? What kinds of strategies can you employ at that point? If the defense says, I want everything that you have, it is in your custody or control, right? So what are we going to do? Any thoughts?
We want to be doing the same thing we would do with like psychological records, otherwise confidential records. So we can ask for protective orders. We can do redactions. We can't hide the ball, but we can do the same arguments that we do with other types of records and make sure the defense is being able to articulate with specificity what they expect to find in those records, and that there's no other way for them to get that information.
And when you're doing these motions to quash a warrant, if you get a subpoena for all of these records, you want to be able to take that opportunity to educate the judge on what the VAWA protections are all about, what the U-Visa program is about, what the confidentiality means. Again, confidentiality, the VAWA confidentiality isn't necessarily going to usurp us of our obligations under Brady. But if a judge does seem inclined to be letting it in, you would certainly ask for an in-camera review. You would want to make sure the judge would sort of protect your own obligations, but also be protecting the victim, and think about different kinds of protective orders.
So as to VAWA confidentiality, let's go back though. If all you have is the request for the cert, like the request for the cert and the cert itself, that's it. There's no other thing to discover. There's nothing else Brady says you turn over. So you don't go, because we've seen prosecutors try to do this, ask the victim to give you the whole file. You don't go ask the judge to order. You object when opposing counsel tries to make the victim turn over the file. And we have like judicial training and bench cards and like training materials out of the yin yang on this that we can get you to get the judge to educate people. But you don't have to go. It's about what you have control over.
You could perhaps attach the U-Visa the bench materials that you have to your motion to quash. Exactly. Maybe not, but
yeah, you'll see that defense attorneys will try to subpoena the immigration attorney, the advocate. You'll see all of that. So this is where the work of Equitas and NIWAP can help you handle those motions that you might get. Is that what you were talking about?
I guess just like in a very common situation where a victim tells me, hey, my immigration attorney wants a copy of the police reports, like, is that discoverable?
No. I mean, there's no harm in telling, I got a request, I gave them a copy of the defense. That's not relevant to anything. It's not material to anything.
Yeah.
So are you just saying the knowledge that they have an immigration attorney?
Yeah, I guess there's just a lot of like kind of gray areas where people talk about like, hey, I have an immigration attorney and we're kind of looking into like benefits or something along those lines. And so I just feel like there's a lot of kind of ambiguous situations that come up in terms of like.
There's a lot of case law that says your victim's immigration status is absolutely irrelevant. It becomes irrelevant when they're asking something of you like a benefit. So if they're applying for a U visa and you know that, like, then that's where you want to be careful and make sure you disclose that. But you have under no obligation to just turn over to the defense that your victim's undocumented.
And the research is on the flash drives. All this stuff is on the flash drives.
Yeah. So the immigration status of your victim is not discoverable. So if that's all that it's material to, then it's not something you need to turn over.
So I just had a follow-up question as far as when that has to be turned over, because we have encountered prosecutors that feel like as soon as a U-cert is requested, they feel the need to, or they feel obligated to disclose that to defense counsel. And what I'm hearing is that if defense counsel asks for it, they are required, but otherwise, no.
I will rephrase that. You have a proactive, ethical duty to turn over a request for a U visa. That is under Brady. That's ethical. You have to do that if somebody requests a U visa cert from me or law enforcement. So there's a discovery responsibility and there's a due process Brady responsibility, and you have both. And you have to do both. Yes. So, with 2 minutes left, I'm going to give you the present wrapped up in a bow, which is really a successful strategy. And this is rebuttal testimony, otherwise known as prior consistent statements. Prior consistent statements are an underutilized non-hearsay or exception to hearsay. I don't know what it is in Minneapolis or Minnesota. It's what?
It's the same citation in our rules of evidence.
Okay. So basically what this says is that when the defense brings up the fact that a victim in your case or a witness in your case has a bias or a motive to lie, what we're allowed to say is before this motive arose, before this bias arose, they said the same thing. It's called a prior consistent statement. And so in this case, what's the bias? What's the motive? The U visa, right? So how many of you had cases where that victim will have reported or disclosed their victimization to a friend, a coworker, a family member, even to the police, prior to them ever knowing about the U visa? Most times, that's what's happening. So what this does is this opens the door for us to bring in prior consistent statement. It's non-hearsay, it's not subject to Crawford, and the way that it works is this. A victim's going to talk about what happened to them. Then they're going to learn about the U visa. That's the motive to lie, according to the courts. They're going to come to court, they're going to testify about what happened to them. The defense is going to say, aren't you just lying about this to get your visa? And then you're going to go to the court and you're going to say, Your Honor, I want permission to enter into a prior consistent statement. Before this victim ever knew about the U visa, the victim told her friend, the victim told her mom, the victim told her boss, the victim told this detective. And those all come in as prior consistent statements offered to rebut the defense attorney's explicit or implicit charge that they're lying for that benefit. So that's the timeline. You need to have the timeline correct. You need to be prepped with your case law that allows this, and much of the U visa case law does say this. The courts will actually say to the defense attorney, you want to bring this up? If you bring it up, you're opening the door to prior consistent testimony. And so there's a lot of standing there. And what happens is these statements that were previously inadmissible hearsay now come in under this consistent statement theory. This is one of the only times that the prosecutor gets to surprise the defense, because we don't do this pre-trial. It has to only happen once that door is open. So you've got to be prepared in the middle of trial to brief your judge about this. So that's the thing. Have those motions prepared and be ready to do it. And it can happen in opening statement. Most likely it happens in cross-examination, but that defense can open the door at any time during trial, and then you want to walk and be prepared to walk in that door with all these beautiful statements that they provided. And there we go.
Speaks to the exact thing that you said. Yes.
There we go.
Oh, I'm sorry. Yes.
With the bow.
Yes.
Is that the bow?
It's the bow. Then there's another case that has some great language. Now, this is probably maybe a little it's a little inflammatory, maybe a little bit on the edge, but it's a great comment, and it did not result in a reversal or prosecutorial misconduct. So I guess we can all say it.
Yeah, I'd probably just tamper this down a little bit.
Yep. It really kind of encapsulates everything that we talked about and all the good reasons why we are doing these certs.
So we need to wrap. We've reached the end of our time today. I want to remind you about resources that are on your flash drives. There's some more flash drives there that you can pick up on the way out. We will email you a link to the webpage. Please take a moment before you leave to fill out the evaluations. And we have certificates of attendance for everyone. So in order to get the certificates of attendance, you have to hand us the evaluations. So you give us the evaluation, so carrot and stick, right? Give us the... Yeah. Yeah.
You need to pre-register for this.
Okay. Sorry. Okay, 1 second, Michelle.
Yes, so I just want to say thank you so much to our NIWAP presenters. A round of applause, please, for Leslie, Tara, Michael, and Jane. Thank you very much for all the information that you shared so efficiently today. Thank you all for the people who are here in this room. You can spread the word to others. You can share information with others, whether they're people you work with or people in community. Please know that Edmundo and myself also co-host a UNT opportunity to connect once every other month. And I'll invite Edmundo to come up and introduce himself as well as my counterpart in the city of St. Paul.
Thanks, Michelle. I'm Edmundo Lijo. As Michelle said, I'm her counterpart in St. Paul. I'm with the city attorney's office. I'm an assistant city attorney, but I manage and run the immigrant refugee program for the city of St. Paul. And I just want to say thank you for coming and really encourage everyone to join our UNT visa meeting because we do share information. We have our certifiers from each city that attend. We also have practitioners. A lot of the nonprofits show up. So it's an opportunity to actually discuss issues that come up with UNT visas. Issues like, if practitioners are submitting too much information, we can talk about that issue and learn about what it is the certifiers need, and really kind of help each other. So it's a great opportunity. It's quarterly, and I really encourage everyone here to sign on and get on our email list and join the meeting. Thanks.
Thank you, everybody. Have a wonderful afternoon.